the X stream. And normally when I start the YouTube, it just begins and pops up, but it has, oh, there we go. Okay, hello. Those of you who did not see my previous welcome on YouTube. I'm sorry. I apologize. When I initially launched the YouTube and dropped my water bottle, I had the wrong title set up for the YouTube, so please forgive me ahead of time for that. I'm glad to be back with you, though, and I'm glad you're here as well. I was just explaining to the wonderful folks on Twitter, we're going to go over the major development related to Aiden Kearney, Karen Reed, and Hank Brennan being called into court related to Aiden Kearney's cell phones and the contents thereof. And then we're going to talk about the historic implications of a juror from Karen Reed's first mistrial who was apparently pro-Karen Reed, potentially a Turtle Boy fan, being added to Karen Reed's legal team for the retrial. Hello, Dee. Very nice to see you. Glad to have some folks with us on YouTube. Now, before we do that, there's something I want to do with you all, which is I want to read the context of why this situation regarding Aiden Kearney's phone is so explosive. And to my own peril, I did not move my microphone stand yet again. So I'm going to use my mouse to help you all zoom in here because we don't need that whole part of the screen up. And then what we're going to do is I'm going to take you through a post, actually, that I wrote that I think is quite important related to this specific background. And we're going to talk a little bit about why Aiden Kearney's phones are so important in the context of this case. And we're going to talk about the history in the context of how Karen Reed and Aiden Kearney met, which strangely was through a woman named Natalie, who's also on the witness list. And then I think Jen Altman was somehow involved in that as well. All right, so the first thing we're going to do here is I am going to bring up the correct window. So give me 1 second. All right, are we on the right window? All right, there we go. We're on the right window. And then I'm going to just scroll this top part up a little bit. All right, so that's much better. All right, now what I'm going to do for you here is we're going to go to my profile and we are going to scroll back because the context leading up to this hearing that we now know, we don't know exactly when it's going to happen, but we have some idea that it is going to happen, related clearly in the next few days, related to Aiden Kearney, Karen Reed, and Kearney's phone. I can read this background now, and I think it's actually serendipitous in some ways and fated, and I'm grateful for that I'm going to read it to you now because it makes way more sense compared to Kearney's, talking about in the context of Kearney's motion to quash the subpoena that was filed for his testimony that you can see up on your screen right there. It actually makes more sense to read it in the context of the development that just happened here regarding to the contents of Kearney's 2 searched phones, which were searched in November of 2024, just being turned over to Hank Brennan subject to an impoundment order and the Reed defense. So now those parties are going through them, and that must be stunning. So although we don't know what they are, we cannot see the contents of the phone. I can tell you a few things. One, Kearney had 6 phones seized. 2 of them were searched in November of 2024 after a long, drawn-out process to make that happen. And then another one of those phones, 4 of those phones were subject to further review by a taint team. I believe that it is the contents of the first 2 phones that are actually the most potentially damaging and explosive to Kearney. Those 2 phones, and that's why, although Kearney is saying a lot of confidence, he's saying things like this. Let's take
David Yannetti with others who, David Yannetti with others, whoever, you know, he wants those because he must have gotten, I guarantee they read my messages with those guys and they were like, hey, you can misinterpret this as part of the witness intimidation statute. That's what they're going to do. They're like, he wants access to, Hank will call anything witness intimidation, like something completely innocent, innocuous. He will call it witness intimidation based on their bizarre interpretation of the statute. That's what we're worried about, is them just calling anything witness intimidation. Like, you know, they're going to do it. So, he wants those messages, okay? He is not getting them. That was denied. What he's getting are any communications between Karen Reed and myself in which we discuss, so you don't get all the messages between me and Karen Reed, with David Yannetti.
So we can talk about more about what exactly Hank Brennan got access to, but let me just say that I think even Aiden Kearney talking about these messages that between him and Karen Reed in that way is indicative. And then there are also leaks, of course, about that hint at the content of those messages. However, we're not going to, I think the best way to do it, as I said here, and we're not going to play this song because we are on YouTube, but I'm going to read this for you. The reason I'm going to read it for you is, although it starts off, it actually gets right into the point. This post that I wrote is the way to understand the hearing that's going to happen between Karen Reed, Aiden Kearney, and Hank Brennan related to these Aiden Kearney's phones, okay? So we're going to do a dramatic towel reading. And it won't actually be dramatic. It'll more just be me reading a post that happens to be very poignant related to the development on the docket that just occurred. I'm not omniscient or omnipresent or prescient in that regard. I'm just a towel. Although on March 9th, I did predict that Aiden Kearney was going to get called on the Karen Reed witness list before it happened, because I'm a towel. All right, so let's understand what this hearing in the next few days, we don't know exactly when it's going to be, but what this hearing is going to be about. Of all the courthouses in all the worlds, she walks into mine. Good morning, towel friends. For those unraveling the tangled web between Aiden Turtleboy Kearney and Karen Reed, this chart, which I attach at the bottom, illuminates the ongoing revelations. It's not just what Kearney confided in Reed. It's what he leaked, igniting a fuse towards a dramatic reckoning. Last week, Prosecutor Hank Brennan gained access to messages on Kearney's phone. That was when the ruling came down. The messages were actually not turned in until today. From April to October of 2023, capturing his exchanges with Reed and her lawyers, David Yannetti and Alan Jackson. Existing records also confirmed direct communications between Kearney and Reed's legal team. Read more about the links between Reed, Yannetti, and Jackson here. Then I provide a link. Kearney now joins Reed's former friend Natalie and journalist Gretchen Voss on the state's witness list for Reed's retrial. Brennan's aim? Not likely, he has declared, a consciousness of guilt instruction against Reed, wielding Kearney's testimony as a devastating blow. Read more background on Kearney and Voss being added to the witness list here. Read more about the state's updated witness list, including Natalie, here. As I've detailed, Brennan can, secure the instruction. I have a medical condition that involves my stomach. I'm sorry, you have to deal with it. As I've detailed, Brennan can secure this instruction and present evidence to the jury without charging Reed with witness intimidation. Under state and federal case law, a joint venture can be proven by a preponderance of evidence for a jury instruction motion, enabling Brennan to admit statements under FRE 801D2E, which is the co-conspirator exception to the hearsay rule, which also incorporates by reference pursuant to Mazian and Borgelli the concept of a joint venture without an underlying indictment, to obtain that instruction for consciousness of guilt, which explicitly addresses witness intimidation. And I hope folks are understanding what I'm saying there. Brennan's going to win his consciousness of guilt motion, and Aiden Kearney is going to testify. And we talked about it a little bit on the stream yesterday, just as a pause here for some annotated commentary. But it's not just that Aiden Kearney is going to testify. It is that Aiden Kearney, whether he cooperates or not, is going to get a grant of immunity, in my opinion, and not be permitted to take the fifth on the stand. And if you think about the Young Thug trial, right, with, what was it, Woody? Little Woody? Something along those lines. I don't remember the guy's name. But he got a compelled grant of immunity, and he wouldn't testify, even though, although that situation was weird, because the first judge in the case, dragged him into chambers with a witness and had, with the prosecutor, and had this, ex parte colloquy where he, was threatening the witness. It was a huge problem. You want to talk about judicial misconduct. The Karen Reed case, as to the way it's been handled by Judge Cannoni, is the epitome, the gold star of judicial conduct. Look at that Young Thug case, or the YSL case. I don't remember the specific caption header. It had 30 defendants. Look at that case and how the first judge, who ended up thrown off the case against his wishes, he denied the recusal motion, handled the witness who refused to testify with a grant of immunity. And then look at how Judge Kearney acts. Judge Kearney would never do that. Never bring a witness into chambers ex parte with the prosecutor and yell at them. Never happened, never will happen. But that was down in Georgia. It was somewhere down in the South where you want to... I don't think some of us up in Massachusetts who yell on and on and on about our judicial system understand what it's like to practice law in the South. That's my commentary on that. But the other thing is, the insight here is that witness it didn't take immunity, got given immunity against their will. And do you know what happened when that witness wouldn't testify? They got thrown in jail for months on end, literally months on end, until they agreed to testify. And the same thing happened to Chelsea Manning when she got subpoenaed in the WikiLeaks federal grand jury. She refused to testify, and she had to sit in jail until the grand jury's term expired. Hello, folks, just joining. Good to see you, Alex. So the context here, by the way, what I'm explaining is if Aiden Kearney, who is on the witness list and clearly got a subpoena, and do his Tecum, because he moved to Quash, which is docket number 611.1 on the Reed docket. He moved to Quash recently. And I know it's recently because even though it said it went up on 3/18, it didn't actually show up on the docket until yesterday, and I monitored it very closely so I would know. But he moved to Quash, so he clearly got subpoenaed. So it's not just he's on the witness list. He's getting called. So that means as soon as the presentation of evidence starts, probably the first witness. I don't think openings are technically evidence. Maybe they are, but he's going to be sequestered, and he's not getting out of it, and he's not going to quash the subpoena. Just no chance. Not in Massachusetts. But the reason I'm saying it is Brennan's not just calling Aiden Kearney because he wants to call him to the stand. Although I think Brennan's going to absolutely decimate Aiden Kearney. He's calling him because there's a larger context here towards consciousness of guilt. Now, remind me if someone can. I'll try to remind myself. I want to watch a video with you all at some point to take a break from talking, where we look at Hank Brennan's interview with Marjorie Egan. Marjorie is a wonderful human being, by the way. Her and Jim are just legends in the Massachusetts news world, and I have known them forever. And I have this great picture with me, Jim, and Marjorie at some event. I think it was an Ayanna Presley event, interestingly enough, but some event, and it is just my favorite picture of all time. I'll try to find it for you guys if I can during the stream. But that's not the point. We're going to watch the interview with Hank Brennan and Marjorie Egan because I want to show you not just I learned today what Hank Brennan did to Stephen the Rifleman Flemmi on the stand. He literally got, we have to actually watch it, but Hank Brennan got, the victims of Whitey Bulger to be hugging him in the courtroom, even though he was getting Stephen the Rifleman Flemmi to basically exonerate Bulger on one of the 32 counts of Bulger's federal indictment. I think Bulger was convicted on 31 counts and then exonerated on the 32nd, which was because of Brennan's cross of Stephen the Rifleman Flemmi. So one, Brennan's just a monster. If you haven't figured it out yet from his strategy, his emotions, his tactics, his analytical framework, the man is a fucking monster. And I'm working on not cussing as much to refine my syntactical precision, but the man is an absolute genius. Now, combine that with what we're going to watch the clip for, which is I finally figured out why Hank Brennan was added to this case. I finally figured it out. I was like, it can't be because he knows X, Y, or Z. It has to be, or he got a referral. It has to be because this man not only is a methodical genius, but because he had insight about the federal probe. And I finally put it together. When he represented Whitey Bulger, part of what that entailed was doing reconstruction a la Dick Layer and Gerard O'Neill for Black Mass to understand how Conley and Bulger were able to manipulate the internal workings of the FBI system in order to run cover for Bulger in order to let him continue wreaking havoc in South Boston, while at the same time feeding the federal government useful information to take down the disparate warring factions that were arising out of the Boston Irish mob wars at that time. And if you think about that contextualized history, which, by the way, only really led to the Angiulo brothers, who were the Patriarchas men in Boston, taking over because all the Irish gangs just ended up falling off because it was brutal. situation with Conley and Bulger ended up playing out in very similar ways, although in a different form, with Karen Reed and her attorneys and their proximity to the old DOJ under Rachel Rollins and Josh Levy. And only a man like Hank Brennan could have figured that out. And that was the genius tactical move. We talk a lot about because we see it in court, but the genius of Hank Brennan. But whatever you want to say about the people around Michael Morrissey, I think this play was actually Michael Morrissey's to bring on Hank Brennan. And once we watch this clip later with Marjorie Egan and Brennan, I think you all will come to agree with me. This was tactical, sublime tactical genius on a level at Hank Brennan's, if not above, from Michael Morrissey. And this poor man, I mean, I feel very bad for him. All he wanted to do was prosecute this case, which is literally his job. The grand jury handed up the indictment. He's prosecuting the case. He's got his ADAs working on it, and he suffered for it, I think, completely unnecessarily and gratuitously, much like some other players in this story, like Lindsay Catani and others, just suffered Michael Proctor completely gratuitously, and John's family and the witnesses and everyone else involved. And it just makes me incredibly sad that that level of genius is not appreciated more. People get so lost in the polemics, they don't see what's actually happening. But that is a little bit of an aside, the Brennan situation that I want to play that clip for. I was just commenting on more just the implications there of Aiden Kearney being called as a witness in the context of the consciousness of guilt play under Mahoney. We have to keep in mind why these phones are coming in, why Kearney is being called as a witness. This is not like a maybe or a rebuttal witness. This is case in chief, justifying why the evidence, why Kearney needs to be called, justifying why Kearney's going to authenticate the evidence. And clearly the fact that Judge Stitzley has ordered a hearing on these phones, like immediately, like something is fucking big. Something's going on, folks. I'm telling you, this is, someone left a gif of a, exploding bombshell in the comments. That is exactly what's going on. So I'm going to continue reading the background here because I don't want to get distracted. Then I'm going to look at comments and questions at the end. So if you have comments and questions about what you're seeing on the screen and what we're talking about related to Kearney and these phones and what developments happened today, don't worry. We're going to go through that. I'll update you on there were 4 or 5 updates that happened today, not just the juror from the first trial joining Reed's legal team, which in and of itself would have been a huge piece of news. We'll talk about the other updates. Reed lost a motion to try to exclude one of the state's witnesses who's going to testify about John's injuries to his head potentially occurring by him falling down and hitting the hard ground after allegedly being struck by Karen's SUV, which was going in reverse at 4.2 miles an hour at around 12:31 a.m. on January 29, 2022, whereupon Reed then, while drunk, left the scene in her car, returned probably around 5:23 a.m., confirmed John was dead, left the scene again, went to Jen McCabe's, went back to 1 Meadows Ave, John's house, told Jen McCabe and Kerry Roberts they needed to leave John's house because John wasn't there, and then brought the women back to Fairview Road, whereupon, in a blizzard through the dark, Karen saw John's body before the women passed the tree line of the house in Kerry's car because Karen had conveniently left the murder weapon back at Fairview Road with a smashed taillight. Then Karen was hospitalized for threats of self-harm by her own family, and whereupon Karen arrived at the hospital, she had her blood alcohol taken, which came out at a .08 at like 8 or 9 in the morning, and therefore a retrograde BAC extrapolation confirmed that Karen's BAC at the time that she allegedly struck John was between .13 and .29, somewhere between 2 and 4 times the legal limit. And that's why I think Karen's parents are so committed to this and trying to help her so much, because they feel incredibly guilty that they sent her to the hospital and ended up providing the state with extremely damning evidence against Karen, even though they loved her and just didn't want her to die. Fate is a very dual-edged sword in that way. A very dual-edged sword. Okay, so that's the consciousness of guilt play, and we're going to talk more about that a little bit later. The evidence mounts. Kearney's actions in the Reed case over recent years, incriminating records on both his and Reed's phones, his witness list status, and his disclosures to journalist Lindsay Catani, sometimes verbatim quotes of Reed's words in 2023, especially about the now closed federal probe into John O'Keefe's death. Read more on what Kearney revealed to Catani about the Reed-Josh Levy connection and why that disclosure is the crux of this entire tale here. It's also why Lindsay suffered so much, because I think Karen came to really resent Aiden for, one, leaking all that stuff to Lindsay, and then also because Aiden's behavior on and actions on 12/23/2023 and his subsequent declaring himself a fugitive from justice and then getting his bail revoked for 60 days led to Karen saying in a text message on March 4th, 2024 that has now been leaked that Karen views Aiden as a risk. So I think Aiden blames Lindsay for that. And I sometimes wonder if Karen actually feels a little bit guilty that Lindsay got caught up in all this proxy war, because it's very high-level political stuff. And I did once ask Karen if she wanted to apologize to Lindsay. I don't really think Karen meant for that to happen to Lindsay. I don't think by Karen saying to Aiden, like, what the fuck are you doing? She was saying throw Lindsay under the bus to get back in my good graces. But I think that's how Aiden took it. He was like, oh, if I can just fuck Lindsay's reputation up and just torment her, then maybe Karen will love me again and take me back into her inner circle. That's what I think really drew a lot of the discrediting of Lindsay. It was just so people didn't realize these two basic facts. Aiden blabbed about Karen's connection to the DOJ, to Lindsay, and then also Aiden became a risk to Karen because of his actions on the 23rd. And, you know, I don't know, love's a weird thing. Like, that man was definitely in love with Lindsay Catani. Okay? I know what those messages he was sending said. Like, he was in love with her. And he got out of control, and I don't know, he made bad choices. And in my opinion, that combined with what he was telling her would cause Lindsay Catani to become a liability, and that's why so many people wanted to undermine and smear her. But I do wonder, and I hope maybe one day Karen will sit for an interview with me, whether she goes to jail or whatever it is later in life. And I just want to ask her, you know, like, a lot of people say, you know, you're just soulless, whatever, but I don't really believe that. You know, like, I think that you as a religious person and like a family-based person and someone who cares about kids, like, I truly believe those things. And as much as Karen says she didn't want kids, I think, like, she still, like, loved those kids, John's niece and nephew. Like, if something happened to them, I'm sure she would have immediately come to their aid and whatever it was. So I would say to her, like, did you feel, everything else aside, like, over that situation, like, just because Kearney blabbed about your connection to Levy, and because of Kearney's indiscretions on 12/23/23, do you think Lindsay should have suffered for that? You know, and I hope she would say no. Just any human, I hope, would say no. But that's the context there about why this initial connection between Kearney, Reed, and Reed and Josh Levy became such a problem, because Karen should not have been speaking to Josh Levy, and the federal DOJ, because of because of deep-seated tensions between Rachel Rollins and the Norfolk DA Michael Morrissey, along with the head of the Public Integrity Unit, Dustin Chow, at the Boston DOJ, who also had deep-seated tensions with Morrissey because Chow's wife got passed over for promotion, while the Norfolk DA and the U.S. Attorney's Office were working on a case in 2015, ironically involving Stephen the Rifleman Fleming. What? Hold on. 2015, the Norfolk DA and the U.S. Attorney's Office are working together on a prosecution, because murders are in the original jurisdiction of the state police, that it involves Whitey Bulger, Stephen the Rifleman Fleming, and Frank Cadillac Salemi. I gotta look at the date on this YouTube video with Hank Brennan. But that's another reason why Hank Brennan is involved in this. Hank Brennan was involved in the Bulger defense, and there was that joint prosecution related to the murder in Sharon, and the U.S. Attorney's Office and the Norfolk DA were working on that case, and that's where the history of tension between Dustin Chow and Michael Morrissey comes from. Brennan must know this like the back of his hand. I wonder if Hank Brennan is the only person outside of this little towel, and maybe Dick Layer and Gerard O'Neill, who know all this. But it makes perfect sense in some ways, because that 2015 case, that was the source of the tension between Dustin Chow and the public integrity section, so folks realize. We're talking about this now confirmed as closed federal probe into John O'Keefe's death. The public integrity section investigates misconduct among public officials. Dustin Chow was a line prosecutor, maybe the head of the public integrity section back in the old DOJ. I don't want to, and I don't keep track of active DOJ positions right now. But the other important context is that Rachel Rollins was the former Suffolk County District Attorney. And Rachel Rollins had two sources of feuds, of tension with Michael Morrissey, the Norfolk DA. One of which had to do with Rollins being a very soft on crime prosecutor, wherein she would not really prosecute low-level offenses, and then that drew criticism from other DAs and then pushback from Rollins. And then the other issue was Rollins was one of the first people, and she eventually was vindicated by the SJC many years later. Rollins was one of the first people pushing to not sentence people 18 to 21 or 18 to 25 to life in prison because their brains haven't fully developed. Now, that caused pushback from the other DAs as well. It caused a lot of tension between Morrissey and Rollins. I think she called him a meatball or something, and she just generally looked at him with disdain. Now, what's weird, though, is that Rachel Rollins got forced out of her job by the Department of Justice Office of the Inspector General in May of 2023, because after Rollins left the Suffolk County District Attorney position to take the U.S. Attorney position after being nominated and confirmed under the Biden administration, that seat was filled by Republican Governor Charlie Baker, and Baker put into that seat Kevin Hayden, who was a Democrat, but definitely a moderate-leaning Democrat, and no Rachel Rollins. And the reason why Baker could fill the seat on an interim basis is Rollins took the position midterm to go take the U.S. Attorney position. And so therefore the Suffolk DA position became open. The governor nominates or fills the position until a special election. That special election, the primary, involved a candidate named Ricardo Arroyo, who was then a Boston city councilor, who was an ally of Rachel Rollins. Now, Ricardo Arroyo lost the primary race, and immediately after, Rachel Rollins, who was U.S. attorney, started texting Ricardo Arroyo that Kevin Hayden would pay for beating Ricardo Arroyo in that primary. Now, here's what's fascinating. What did Rachel Rollins do? Rachel Rollins launched a pretextual federal investigation into Kevin Hayden, recused herself from it, and then leaked the recusal letter to the Globe and the Herald to just try to smear Hayden, and then got fired for it. Pushed out, I should say. Now, you want to know something even more interesting, by the way? Why do you folks think Rachel Rollins got hired for the position of U.S. Attorney if she basically immediately got forced out by launching a pretextual federal probe into Kevin Hayden? Did you ever ask yourself, and we're taking a little pause here talking about Turtle Boy and his phones coming into Karen Reed's retrial and this big hearing coming up. To those of you in the Massachusetts political world, have you ever asked yourself about that 2020 Senate race between Joe Kennedy Jr., the redhead, and Ed Markey, the current senator, JFK's old Senate seat? Did you ever ask yourself about that race and a spoiler candidate, a Republican spoiler candidate named Rayla Campbell? Now ask yourself further, why would Turtle Boy and Rachel Rollins be having direct communications about Rayla Campbell going to Joe Kennedy events to sabotage Kennedy's campaign? Rayla Campbell, the virulent Republican, Turtle Boy, who got banned from the church apparently next to the Karen Reed trial because he was a bigot against transsexual people or something. That's what he was saying on his stream last night. And I was just like, what the? And then he was like, but I want to be clear, I'm not bigoted against gay or bi people, just transsexual people. And I was like, what the fuck, Turtle Boy? Like, what the fuck? Are you being political, or can you really not see the really stupid bifurcation you're trying to make there? And can you just not be bigoted towards anyone? Oh my God. And then we're not getting into his remarks about what he was going to do to Karen Reed's private parts. And I'm not sure why he thinks Karen Reed has male private parts, or if that was some kind of aphorism, but we're not really going down that road. Because what we're talking about right now is Turtle Boy, the virulent Republican, is teaming up with Rachel Rollins, the liberal, a very progressive liberal Democrat, to have Rayla Campbell, the virulent Republican, go to Joe Kennedy events to help Ed Markey. Now, do you think it's any coincidence, folks, that then Rachel Rollins somehow gets this connection to the Biden White House? And do we really think it's any coincidence that Aiden Kearney was proud that he helped get a January 6th rioter convicted? And do we really think it's any coincidence that for years there was this weird NSC 131 orbited group tied into like Boston Free Speech and Resist Marxism and all those other networks? You know, like, I think Aiden Kearney was helping some people, maybe in a benevolent way, but definitely not like Republican friendly. I think he was helping the liberal Democrats and had some really high-ranking connections as a result. But that was in the years leading up to the Reed trial. But just keep that in mind, because Rachel Rollins has this web of connections independent of the Reed case to Turtle Boy. Rachel Rollins has got this pretextual, or I should say pre-existing feud with Michael Morrissey on two different levels. Dustin Chow's got his own feud. And then you got Karen Reed walking into Josh Levy's office with Alan Jackson and David Yannetti in November of 2022, spinning up the exact kind of tale of police misconduct that would get folks involved, the DOJ involved in something like this, even if we're entirely baseless. But for the fact that probe happened to stumble on the cover-up of Sandra Birchmore's murder, I think there would literally be congressional investigations right now into Josh Levy and Rachel Rollins and all of these players. But the only reason there's cover for that is because this MSP unit that was investigating Karen Reed really did sign off on Sandra Birchmore's murder as the result of self-harm when it clearly was not, and when they clearly had evidence that it was not. And I think that's the big secret everyone's trying to hide. But okay, so we have to continue because that comes up in this story. But just remember, folks, all of these layers are at play here with Aiden Kearney's phone and his messages to Karen Reed, because it was about the federal probe that Reed and Kearney were talking, and then Kearney was blabbing about. So, folks, we just remember the context here. It sounds like it's multi-layered and dynamic, and there's a lot of players to keep track of. Yes, but that's why this is so explosive. It's not just that there's a hearing happening. It's that the contents of these phones go to the heart of what is a very serious situation and could expose a lot of very powerful people. So let's continue. The conclusion, and by the way, I was writing this days ago, so the conclusion seems inevitable. Kearney will be compelled to testify against Reed, whether he wants to or not. Gretchen Voss's testimony will tighten the vice. She holds recordings of Reed admitting, before her lawyers, that Yannetti warned of potential culpability if Reed struck O'Keefe, even accidentally, at 12:31 a.m. on 1/29/2022. A July 2023 recording captures Jackson proposing to launder protected court documents via the Brian Walsh case, offering Voss cover to use them, a scheme she declined, per evidence. And my evidence there is that Voss didn't mention any of those protected documents in her articles. And I think after what Hank Brennan's planning, by the way, which I don't know if I lay out here, but what I think Hank Brennan's planning is he's going to call Voss to have Voss authenticate the recordings from some of the interviews in Karen's home, and then also to authenticate the recording of the Seaport interview, which Voss never mentioned, like meeting with Alan Jackson and recording him at the Seaport. And then I think Brennan's going to lead up to, and you didn't do this, right, Ms. Voss? You wouldn't go along with it, and that not in that leading form. Voss is going to testify like, yeah, I would not go along with it. And then Kearney's going to get called, and it's going to be demonstrated to the jury like, oh, the Reed's team got desperate. They went to Kearney, who would go along with this plan and other plans. Reed's legal defenses are collapsing. Last week, Judge Dennis Saylor denied her federal appeal to stay state proceedings. Karen's pretrial motion to dismiss is also futile. It ended up being denied. She didn't request CPD Sallyport video until November of 2024. Boom, cited in the denial. 3 videos show her taillight broken before reaching CPD on 1/29/2022. We didn't even get to that issue because the CPD footage was so grainy that it couldn't be relevant, so Reed just lost. John Fanning never oversaw jurors. Oh, God, yeah, we got a whole section in the denial about how bad it was for Reed to make that argument. And Jackson refused to recall Jen McCabe for cross despite a Rule 14 violation mid-trial. Yeah, it was Jackson who committed the Rule 14 violation, and then he didn't want to recall her. And Judge Cannoni literally quoted Jackson's braggadocio and then didn't comment on it and was just like, Mr. Jackson, I'm thinking what Judge Cannoni would have said. Mr. Jackson, your own words seal your fate here. You said to the court that you, quote, destroyed Miss McCabe, and you didn't need to call her back. Just ended with a quote. She didn't do an IRAC in that section. Judge Cannoni wrote the most eloquent destruction of a lawyer I've ever seen by just using his own words against him. Good job, Judge Cannoni. I don't know Judge Cannoni, never spoken to Judge Cannoni, never intend to speak to Judge Cannoni, maybe after she's retired or something. But my word, that judge has a way with structure and words. And it's not like a federal opinion, which is very, it's like a historical treatise. Judge Cannoni's opinions are very filled with state law and then very, cutting, dry wit and criticism. It's like the vibe you get from reading a Judge Kearney motion is like, I have a lot to say and I am fed up with all of you. Except for Hank Brennan. I think generally she thinks Hank Brennan is doing like the right thing. And that's not like a bias or not, because Judge Kearney rules in favor of Reed, rules against Reed, rules for the state, rules against the state, rules against them both on joint motions. It's not that. It's just I think that Judge Kearney isn't as offended by Hank Brennan's posturing and legal tactics. Okay, so Karen faces a Sisyphean reckoning. Despite Jackson's efforts, his overreaching tactics, his singed Icarus wings, have toppled her seaport war room. History encroaches. Flak towers crumble into bomb shelters, supporters flee, and the naive are devoured like cannon fodder. Imagine Reed amidst the ruins of her once grand city, longing for 99 pink balloons to rise from a cratered promenade, a futile hope. No new dawn awaits. Karen's moral salvation lingers as a dream deferred in this tragic nightmare. The world moves on, faintly recalling Reed's struggle against truth, and even less of John O'Keefe, the great man she erased from this earth, a hero who touched countless lives. This is history's curse. The best laid plans of turtles, towels, and titans crumble before fate's heartbreaking synthesis. Bittersweet. We cue as time goes by, asking Sam to play it once more, lining the streets to mourn a battlefield scarred by the silent screams of untold innocence. To look away is cowardice. To shy from telling this tale is to evade duty. The true cost of sin isn't ours to bear. It's etched into the sands of time, a lesson in fragile human frailty, forever carved into our collective subconsciousness of guilt. That was intentional. I feel no pity for Karen in the ruins of her once lavish bunker. No sorrow for someone who turned beautiful, precious human lives into pawns in a political battle of wills. I see only a frail figure, watching the last embers of an insidious PR empire burn to ash between her brittle fingers. In that vicarious catharsis, I find tempered solace. I cannot predict the days and weeks ahead, nor do I wish to peer into that ether, fearing the conclusion might crush what little spirit I have left to chronicle this chaos. But I know our souls enter this world blessed with the power to right egregious wrongs. Whether we choose to do so, or let hatred consume us, leading to our own destruction, may be our only chance to break free from fate's chains, glittered with garlands of flowers, as if to distract us from our bondage. The irony cuts deep. The control Reed craves was always near. Moral liberation demands allocution, contrition, compassion, and apologies. Without them, history judges, exacting penalty sans repentance, perpetuating Reed's Joycean cycle of torment, and made manifest in Hegel's unyielding dialectic. Perhaps Karen will find her 99 balloons of hope yet amid the cacophonous polemical blitzkrieg still unfolding before our eyes. But if I have any say, they will descend from above in blue with a black stripe for John. Disclaimer: I am not a lawyer. I am clearly a towel. This is not legal advice. Get a lawyer if you have questions about the law. Get a towel if you want to prove unconditional love is the only remaining North Star in a world defined by despair. What do you think? I thought it was pretty good. There's a lot of layered allusions in there. There's some Rousseau references. Definitely, without saying it, I was comparing her to his last days in the bunker in Berlin. So that's the theme of it. And it's not a coincidence that I used Casablanca, which is about North Africa and the last port before Lisbon for refugees fleeing war-torn Europe in 41 and 42. That was the whole motif, was comparing this to Karen's current defense to the Russian siege of Berlin in those last days. I was doing that on purpose. So yeah, I hope you liked it. We're going to talk more about the Juror situation. The juror from Karen's first trial joining her legal team. the precedent there, the implications. It's never happened before in U.S. history. I cannot find any examples of it. We'll talk about the weighty impact of that. But I want to watch this Hank Brennan clip as well, so I'm going to bring that up for you. And then along with watching the Hank Brennan clip, I want to take some of your comments and questions because I'm a towel. And I appreciate so many of you for tuning in. So what do we got? Oh, we got a lot of comments, and we got a lot of friends watching. I'm so glad so many of you are joining on the YouTube. I haven't been streaming on YouTube a lot. I do most of my streaming on X, where a lot of people seem to like watching. They don't comment as much, and it's hard to see the comments. But yeah, if you're watching on YouTube, apparently it really helps if you like the video while watching it and subscribe if you're not from within the video. It helps the video within the algorithm or something. Don't really know, I don't really understand, but if you're here and you enjoy it, it doesn't cost you anything, and you can click the like button and subscribe. Someone was explaining to me the dynamics of how all of this works within these live videos. I don't really get it. I'm trying to learn. Give me some time. I have other things on my mind, like the integrity of the republic and the justice system and convoluted political proxy battles of will between the Boston DOJ and the Norfolk District Attorney that for some reason impact countless untold innocent lives for, as I said, reasons that I fully cannot understand or appreciate. All right. Okay. Oh, goodness. There are a lot of comments. I can't read all of these comments. I'm sorry. You all had so much to say. Thank you, Trevor. Trevor says, Grant, good to see you streaming. He enjoyed immensely. Yes, it took me a second to get the YouTube going, folks. For whatever reason, I started the first one with the wrong title, and then I got it going. Justice for John O'Keefe and his family. Absolutely. Poor Grant having to eat all this. Sometimes I prefer when he just talks and gives us his own analysis and opinion. I don't know what it is I have to eat. There to read all of it. Yeah, there's a lot of stuff to read. Yesterday, I'll tell you, reading through the 28-page ruling was not as bad as the 50-page motion from the day before, but I'm used to it. I've been reading these court documents on these YouTube streams. You can find them in my archive since the beginning. I didn't use YouTube as much because it's a little convoluted to do 2 streams at once. But yeah, I've been reading 50-page court documents, even back to the Commonwealth's opposition to this defense's original motion to dismiss in the lead up to the first trial. And that's really where I started learning about all the nuances of the facts, and I became very familiar with Adam Lally's writing style. Now I'm familiar with Hank Brennan's writing style. I've always known David Yannetti and Alan Jackson's writing style. I must have read, I don't know. I think I've read every document on this docket, number 1 through whatever we're at, 680 or 650 or whatever we're at. So, yeah, I guess I do have to read a lot. Yes, hit the like button. Thank you, Dee, for the suggestion. I'd have to disagree on this one, Grant. I think her parents are horrific individuals with zero conscience. I didn't say her parents. I don't know them well enough to judge. I said I think it's possible Karen isn't just completely defined by evil. Like, humans are not black and white, and I think even humans who mimic emotion in an inauthentic way, like Karen does, in my opinion, that doesn't mean that their entire world is bereft of emotional intelligence. Like, I still think Karen reacts emotionally to things. It might not be appropriate emotional reaction in all cases, but I think that, like, Karen understands why family is important. Karen understands, like, the concept of love. So I don't think that it's hard for Karen to, as I was talking about when I'm sure that comment came up, understand why I would say to her, well, in particular as to Lindsay Gattani, who became completely collateral damage in this just because Turtle Boy told her things about your communication, Karen Reed, with Josh Levy in the federal probe, now confirmed as closed, and Aiden's actions on 12/23/23. Like, don't you feel some kind of understanding of why that is just, it's not, this may be a war to you, but human lives are not collateral damage. They exist 24 hours a day, and much like Karen, I'm sure she realizes this, it is always on their mind, this whole situation. So do you feel anything about it? Yeah, I get Karen doesn't feel it for the witnesses in her case, and I think that's bad and terrible of her, but she's so hostile towards them. So at least I can understand her justifying it when she goes to bed at night by being like, well, they're trying to do bad things to me, even though Karen, in my opinion, deserves them testifying against her. but with the innocent collateral damage, if there's no remorse there, and I don't need her to respond, I can just ask her the question and feel the vibe. Although she's very guarded, her vibe is very hard to pick up, and there's always a lot of chaos. But I think just if I could ask her questions and she would actually answer them, even if she wouldn't give me direct answers about it, I would be able to tell from her response and her body language and her eyes whether she actually understood emotional pain and in others and could relate to it as a sign of moral failing. I could tell. I don't know. I can't speak to it because it hasn't happened. But I'm sure if I had 20 minutes with her, an hour with her, give me like 4 hours with her, and I could probably read her soul. But if I had some time and could actually get her talking, I think, and that's why she won't talk to me, because I think she knows that her and I are very similar, and we can read people without them talking. And so once you start talking, we can read you even better. So. But I think it would be very interesting. I think I could actually get you all some answers as to what her personality is actually like, and I think I'm willing to give her a chance and say it's not entirely devoid of humanity. Product of her childhood environment. That's a pretty valid insight. Someone said that it's a disgrace. Lisa Cox said it's a disgrace her parents are pushing. She's innocent. You would think it bothers them. I think, as I said, I think they feel incredibly guilty that they sent her to the hospital, even though they were trying to save her life, and it in turn led to her BAC being taken. You know, that's what I think it comes down to for her parents. So, yes, guilt, but at the same time, do you folks understand what that must feel like when you were just trying to help your daughter and you ended up getting her sent to the hospital? And then the other thing I wanted to do is I wanted to bring up this Hank Brennan video for you. We're basically at, I'm not even close to the end of the comments. I heard Hank Brennan went over and spoke to Miss O'Keefe yesterday. I did see that reported. I was in class all morning, so I didn't get there till late, but I saw John DePetro report that. Someone was commenting on Karen's psychoanalysis. You may do that in the chat, but I'm not going to read it. It's up to you. Someone said, who wrote this? Robert Frost. Oh, you're very kind, Trevor McIntyre. I've been really refining my syntax in how I've been writing some of my posts, because I'm thinking about the larger historical narratives, and I don't want to write a Joycean Finnegan's Wake where it's just like paternalistic encoding of meaning. I want it to be a recursive, self-contained historical narrative that demonstrates the cycle of the rise and fall of human morality as encapsulated in the Karen Reed trial, and then I want to just highlight that as just one of many cycles of the rise and fall of human beings, and how the peaks of this case show the redemptive asymptotic benefits of humans striving towards that kind of goodness, and then how the valleys of the case reflect the very dark sort of perils and pain that happen when we fail to perfect our strive towards understanding and universal truth. And so I think in an attempt to remedy or render that complex historical mosaic in an accessible manner, the only way that I can do it is by using adapted literary style and form. And so it's nonfiction, but layered in socio-philosophical historical commentary that has a literary flair. And I think there's some Shakespearean insights that I'm drawing on, because in Shakespeare's time, that's really what he was doing, especially if you're reading Twelfth Night or something. A lot of that is very bawdy commentary, because the plays were meant for a mass audience. Mind you, it was middle century England, but middle 16th or 15th century England, whatever it was. But there were also very strong elements of intellectual undercurrents that were meant as kind of a nod, a wink and a nod to the higher class. And that was the beauty of it, that dichotomy. The documentary's coming in. That is a very, very big idea, a very big deal we'll talk about, but we did talk about that yesterday, but we'll talk about that as well. But I want to put up this Hank Brennan clip. The reason why I want to put it up is, one, I would like to smoke a little bit, and two, I want to just show you all, we talk so much about how brilliant Hank Brennan is, okay? And Hank Brennan is absolutely brilliant. But I want to show you back when Hank Brennan was talking about his involvement with the Whitey Bulger case, the level, why this man, I think, was brought onto this case is because of the level of brilliance that you're about to see here. So let me bring this up for you. I managed to find the clip. It, as I said, is with the wonderful Marjorie Egan. So I'm going to let the ad play off screen so we don't have to watch the ad. Then I'm going to, oh, that's not what I want. Oh, sorry. Hold on. I'm going to have to do it one more time. But yes, I'm going to bring this video up for you, and I think having a chance to watch Hank Brennan talk about this is incredibly worthwhile. And then, of course, as I go to do that, it's being incredibly annoying. But I will not be deterred. Hold on. But yes, I think it's worthwhile both as to what Hank Brennan says, but also just seeing his demeanor and how he talks about the case. All right. Why must you do this to me? For whatever reason, the YouTube video is being very annoying right now. But, as I mentioned, I'm not going to be deterred that easily. And I'm going to bring it up in another browser. All right, I got it working.
All right, well, over the course of 35 days,
so
jurors heard...
actually get the video up on the screen for you. I think I have it in my browser here. All right, looking for Hank Brennan. There we go. All right, give me 1 second. It should pop up right now. Well, it almost worked. There it is. It's in the background. And there we go. All right, 1 second. All right. And you can see this. I think this was the 2015 case because it says 11 years ago. And that's not actually Hank Brennan yet, but he does pop up in 1 second. All right, let's watch. It's actually very interesting, folks. This is a very interesting insight into Hank Brennan that I found today.
All right, well, over the course of 35 days, jurors heard from no less than 72 witnesses. The one person they did not hear from was Whitey Bulger himself, as he declined to testify. After the verdict, defense attorney Jay Kearney spoke for Bulger, saying he was pleased with the outcome.
It was important to him that the government corruption be exposed, and important to him that people see firsthand the deals that the government was able to make with certain people.
And now Hank Brennan, a member of Whitey Bulger's defense team, is here. Welcome, Hank Brennan.
Thank you for having me.
It's been a wild 8-10 weeks for you.
It's been a busy year and a half.
How did your client respond today? We just heard Jay Kearney, your partner in this, say that he wanted to see that the government was partly culpable. But how did he respond to it's 31 out of 32 counts he was proven guilty?
James Bulger was extraordinarily content. I think the moment for him came well before the verdict. It was the effort and the demonstration in court to help try to show as much truth as we could. The idea that the government has some liability and accountability in what had happened over those decades was one of the most important objectives we had.
One of the oddities of this was to see Stephen Davis and other members of families of victims embracing you and Jay Kearney today, and that here you were representing the man who killed their loved ones. What was that like for you to have them almost siding with you in a sense? Not that they didn't want to see the government, convict them, prosecute them and convict them, but they really credit you with bringing out the government part of the corruption.
Well, we expect our criminals to commit crimes. That's what criminals do. We don't expect that from our law enforcement. And so having a very unique opportunity, Jay Kearney and I had the ability and the invitation to do anything we could to try to help find the truth and expose what the government had done. And the government had done a number of things that we don't expect from our government. They not only created victims, but they continued to victimize the victims by denying their responsibility. When we started this case, the effort was at the most important part to help show the role the government played in this entire conspiracy. It was a very liberating experience as a defense attorney to be able to ask questions of witnesses, which in times could implicate our own client, and we did at many points, but also help other people. And I felt the presence of Patricia Donahue and the Donahue family and the Davises behind me every day. I didn't always see them when my back was to them, but I felt their presence, and I knew that what Jay and I, Kearney, were doing had some import, not just for our client, but for the community, for particular victims, and also for the public.
You eviscerated Stephen the Rifleman Flemmi in cross-examination. And as a result of that, you could say that you were actually responsible for the no finding in the murder of Deborah Davis, even though everybody knows he was there. He was never there. He was behind it. He, for one reason or another, wanted her dead. And yet, as I said, the family is still saying, well, you know, they want to go further with this. They want to take it to a state court, but they're fine with that.
Well, I take issue with the suggestion that he was there, and I take issue with the fact that you suggest that they wanted him dead.
Her dead.
Or her dead, I'm sorry. The only person who has ever said that is Stephen Flemmi. Mm-hmm. And certainly when a person that vile decides to kill his girlfriend because she has decided she had an interest in somebody else, someone that vile with that type of reward isn't somebody who's reliable. So I absolutely suggest that's not accurate and that's not true. I think quite the opposite. That being said, in protecting and defending James Bulger at trial, I think we demonstrated through the trial that we didn't pull any punches even if it incriminated James Bulger. Jay Kearney and I, at every step, tried to bring out the most reliable information. There were many witnesses which I asked about not only the Deborah Davis murder, but also how the FBI was complicit in covering up Stephen Flemmi's misconduct by trying to hide the conversations and interviews with Olga Davis and Mickey Davis. So that was a concerted effort throughout the trial. And sometimes public and people, victims like the Davis family, need somebody to stand up for them. And that's why we rely on prosecutors. That's why we rely on our government to do that. And when they fail and someone else is there to take the void, and we had an opportunity to do that, for us, that was very meaningful.
I realized the judge wouldn't allow testimony in that you all wanted, you and Jay Kearney, which was that the government offered Whitey Bulger and Stephen Flemmi and Stephen Weeks, to some extent, immunity from prosecution in order to turn evidence against La Cosa Nostra. But why not let your client testify? I know he said he wanted to in the beginning. Jay Kearney said he would. Why not?
The arrangement that James Bulger had with the federal government was very different than the arrangement that Stephen Flemmi had. James Bulger was never an informant for the federal government. He was never providing information, and I hope we dispelled that through this trial. It's unfortunate that the general public doesn't see this type of trial on TV, and they can actually look at the detail and the evidence that we help show, because unfortunately it still then becomes a matter of rumor and innuendo. James Bulger not only was prepared to take the stand, he expected to take the stand from day one, and is what he wanted to do. There is a story, a sordid story, that extends well beyond the Boston FBI to the Department of Justice to the highest ranks, and James Bulger was prepared to tell that story. It is a loss for everybody, for the jury, for the victims' families, for the community, for the public, not to have him take the stand. I expected he would have been the most convincing witness, because he'd be the one witness who would not try to protect himself. I think that's reinforced by the approach Jay Kearney and I took. But to have somebody take the stand just to give a confession, but not to give the entire story and protect the government, makes absolutely no sense. If the government had no fear of what James Bulger would say, there'd be no reason not to let him testify to his arrangement. If immunity was so absurd, then they simply could have dispelled it in front of the jury. So although the government continually suggests that they're disappointed he didn't testify, they tried to silence him at every turn in this case. And it was an extraordinary loss, because talk about the idea of closure, what better closure could you have than the person who could stand before the jury and the community and say exactly what happened. But fortunately, I don't think this is the last word. It's the end of this trial, but there's perhaps other trials, and there's other opportunities for James Bulger to have his voice heard. And this would have been the perfect forum, but the government wanted to deny that, and they effectively did.
In the evidence file, there were informant cards issued to Brian Halloran, Stephen Fleming, others, among them.
I just want folks to understand what Hank Brennan was saying there, because I think at the time people would have understood it better. Hank Brennan was saying Whitey Bulger wanted to testify, but the government in the federal trial objected to certain components of Bulger's testimony, and so when the judge ruled in the government's favor, Bulger wouldn't testify in a narrow way. That's intense. But I wouldn't doubt Brennan's right there, and I hope you all are starting to see, and we're going to watch a little bit more of this, the point that I was making, which is that Hank Brennan is well aware of how the FBI can sometimes provide cover, and the DOJ, for people that are helpful to them. Karen Reed, maybe at least for a little bit Turtle Boy. But let's keep listening to Hank Brennan.
James Whitey Bulger. I think they just said James Bulger. If he wasn't an informant, why did he have a card?
James Bulger didn't fill out a card and put it in a file to represent himself. It's ironic that the government says that John Conley, who was involved in such complicity and conspiracy and criminal activity, and he cannot be believed, especially with all the detailed reports he gave. But then the reports that may suggest that James Bulger gave information you should believe. There were a number of ways we tried to demonstrate to the...
So just to pause here, if you're wondering, why is Hank Brennan trying so hard to say Whitey Bulger was not an informant? Well, what happened to Whitey Bulger when he got to that prison in Pennsylvania or whatever? He lasted a few days, if that. So I think Hank Brennan was trying to keep his client alive here.
This jury.
You should just clarify that, because James Bulger was saying that he actually paid them off. He gave them information, not the other way around.
They were his paid informants. It is odd that a person who was supposedly an informant is paying so many thousands of dollars to law enforcement when they're supposedly the informant. We showed a number of documents at this trial which showed specifically information that was attributed to James Bulger that was taken from other informant files. File after file and document after document came from other files that predated files and documents in James Bulger's file. The ping sheet and the protocol that you're supposed to go through with an informant was never followed. There was never a signature. There was never a contemporaneous photograph.
Let me interrupt you, because why was this so important? That was never part of the trial. That was not an issue being decided at trial. Why was it so critical of you and your defense team to prove that he was not an informant?
Well, it's a good point. It really wasn't so important to us, but remember, the government raised the issue. From the outset of this case, they wanted to insist that he was an informant. And anytime we saw a fallacy or a fabrication, we tried to check it and counter it and show that it wasn't true. Why do I suspect it was so important to the government? Well, part of it was because of reputation and pride and public relations, but think about the consequence if he wasn't an informant. Here's a person who paid an extraordinary amount of members of the FBI to get information. Inevitably, Washington, D.C. FBI was responsible for reviewing those files for determining whether or not things were viable. We had Mr. Fitzpatrick, who said he tried to shut him down, Mr. Davis, who said that the file was absolutely worthless, and Washington did nothing about it. If James Bulger was not an informant, as he was not, and simply paying the FBI, the accountability goes well beyond John Conley. And so the government certainly doesn't want to accept responsibility and accountability for letting somebody who bribed their officials to exist. Since
you brought up the issue of no cameras in the courtroom, which was incredibly frustrating to us in the news media and to the general public, tell us a little bit about working with Whitey Bulger. What was he like? Did you end up liking him? Was he somebody who was very vocal? Did he speak up on his own behalf? How did he interact with you? Just anything.
James Bulger is an extraordinarily intelligent man, and he is captivating. He's a historian. He was an excellent client. He educated. He gave guidance. He was a good listener. And Jay Kearney and I had an extraordinary relationship with him. There were a number of things that were introduced to me before we got to trial that helped me assist him, and he was an excellent guide. I try to have an affinity for all my clients. Remember, when someone's charged, they're presumed innocent, and they come to you because they need help. And when you tell them, I'm going to treat you like a family member, you treat them like a family member. And if my brother is going to call me at 2 o'clock on a Friday night, I'm going to take the call. And James Bulger is no different than any other client that Jay and I had ever represented, and no different than a family member once you represent him.
He's 83. Was he completely cogent, lucid? Did he show any signs of illness or?
None. Yeah, he's a captivating speaker. I think he would be absolutely mesmerizing to a jury. And if he does at some point have an interview, I won't need to speak for him. He can speak for himself. But at 83 years old, he's equally, if not more, competent to speak on his behalf than I ever would be.
84 next month. All right, Hank
Yes.
Brennan, thank you so much for coming.
Thanks for having me.
So that's a little bit of an interesting window there, I think, into Hank Brennan. Now, obviously, Hank Brennan was a defense attorney, and I think that should absolutely be taken into consideration when we're looking at that video. But I think so much of that provides insight into not only Hank Brennan's intelligence and compassion. Think about what Hank Brennan was saying there. He was like, this is a guilty man. He didn't say it because he would not say that about his own client, but he was like, we put on a strategy that basically involved asking questions of witnesses that inculpated, made our client look guilty. It literally led to guilty verdicts to help the witnesses and the families in the cases. That, to me, is stunning. And then the other thing you hear there is Brennan saying, I didn't like what the FBI was doing to help Whitey Bulger. I thought it was, and the Rifleman Fleming and all of them. I thought it was wrong. And it's wrong that the FBI was taking money. John Conley was taking money from Bulger. You have a man in Hank Brennan who has an institutional understanding of not just the DOJ and the FBI, but how it can be corrupted. Do you know how rare that is? Unless you are like in the OIG for that office, unless you are in that world itself, you would never then be a traitor in this way to it, even though exposing misconduct is not really being a traitor. I'm using that liberally, but you would never do that. So unless you're somehow in the political establishment or in the intelligence community or randomly in the office of the Inspector General for the DOJ, you're never going to understand any of this. In fact, I am 97% sure that, and I'm starting to really think about this more. I don't know if people would even understand the full weight of what the DOJ was doing here. I think Hank Brennan gets it, but I don't think people would understand the full weight of it if I was not saying to people, oh, there are 75 sections of the DOJ, and there's the public integrity section, and there are line prosecutors, and here's Rachel Rollins' history, and here's how she launched the pretextual federal probe and the tension with Morrissey and Dustin Chow. I think this all hides in plain sight because real power doesn't actually brag. It doesn't need to. It has its own systems to effectuate its ends and goals. So it hides in plain sight. And a lot of this stuff, the reason why people can function in such an unaccountable way is that it's really hard to understand. It's very segmented. It's quasi-public. There's not a lot of transparency. And that, I think, is what Hank Brennan was reflecting in his interview. He didn't actually come out and say anything that would compromise national security or anything like that, but you could see this just ferocious distaste with the way the federal government can be weaponized. So that I thought was very insightful. And then also I want to continue over here reading some of the other updates, because now I want to talk a little bit about how absurd it is that Karen Reed, for the first time, 1,500 of you, hello, thank you all for watching on Twitter, I appreciate it. How absurd it is that Karen Reed is attempting to add a juror from her first trial to her own legal team. The juror was a lawyer. And the reason why I want to talk about how incredulous I am about this is I did some research. And I'm not a lawyer, I'm a towel, and none of this is legal advice. But I did some research, and this is unprecedented. And if someone can find me, by the way, this special contest, actually, we'll do a special poll. Hold on, can I do this? Yes, I can. I have special towel abilities. Hold on. We're going to do a towel poll here. How do I do this towel poll? Here we go. Hold on a second. I thought I can click the poll button. All right, here we go. So the question is, has a juror from a defendant's prior mistrial ever joined that defendant's Retrial legal team. And if you can find an answer for this, by the way, special points for you, because I don't think this actually exists. Has a juror from a defendant's prior mistrial ever joined that defendant's retrial legal team? Okay. Yes. I did say yes. And then no. Okay. And then why can't I don't need that. So why can't I don't understand. Oh, here we go. Has a juror from a defendant's prior mistrial ever joined the defendant's retrial legal team? Let's see what people think. I've added a poll. If you have opinions on this, please let me know. Not as opinions. If you have actual citations and can find any example in history, please let me know. Oh, I'm back with the live chat. Let's just jump to the live chat. And then someone said, so stupid, she's a civil lawyer who has only worked employment. What is the advantage of adding this new attorney? Oh, great question, Dixie Doodles. We are going to read the analysis of why this move not only is it historically unprecedented, but why it might actually be tactical. And because it's a question of first impression and implicates a federal constitutional question under the Sixth Amendment, could be an appellate time bomb. So this is actually very important. The first thing about this new hearing before jury impanelment starts was big, very big. That's why I led with it. This is also very important, but it's legally nuanced in its application. So if we're going to talk about it, I need to actually read through all this precedent. But the answer, once we read through this question, will be, the answer to your question will be self-evident once we go through this, because it is a huge, huge, huge question as to whether this has ever happened before. And if the answer is no, then it's a question of first impression. And because it has to do with the defendants adding counsel, by the way, this juror joined David Yanetti's law firm to be added as counsel here. Okay. What happens to what Judge Kearney has to make a ruling? There has to be some kind of discussion. This is going to cause absolute chaos. All right, but let's read some questions. Remember, all right, what do we see here? The judge must bar the defense from telling the current jury that the nutjob lawyer was on the last jury. She should bar all headphones and microphones for Karen too. I don't really know. I don't think she's going to let that lawyer be on the team, the Reed's legal team. I don't think that can happen. Hank Brennan not putting a gag order on Reed. He knows she will dig a massive hole. I agree. Yes. Okay. So we need to actually read this because I think it's important for you all to understand the implications of this. And I did some cursory research, and I'm looking at the chat. If you can find an example that is, I can't prove a negative. Okay. So I cannot prove something does not exist. The only thing I can do is a diagnosis of exclusion, which is I can rule out the fact that after as much extensive searching as I can find through every single mechanism available to me, I have not found an example in American case law where a juror from a criminal defendant's prior mistrial, who was a lawyer on the jury, then did join the defendant's legal team for the retrial. Literally, unheard of, unprecedented. I cannot find a single case. I cannot find a single example. I can't even find people discussing this concept. Now, for that reason, I'm going to read you through this post as well. I'm not gratuitously reading through this post. This is actually the answer to the question of what is going to happen in light of this. Now, I have a lot of thoughts here about how this puts the court in an incredibly difficult position. It puts the prosecutor in a difficult position, and there's two reasons why. Well, there's a lot of reasons why. One, the first option is to just do nothing. The court can simply do nothing and let everything move forward as if this just were just another lawyer. But that's extremely prejudicial to the Commonwealth, and it's extremely prejudicial to the American system of justice. And so what the court really has to think about this. But the reason why this is a big problem is it creates a fait accompli in terms of appeal. If you allow this lawyer to join Reed's team over the objection of the state has to appeal. I mean, this has to be reviewed if this lawyer is added to this team without, and Judge Kearney's okay with it. That if that happens, then the state appeals, okay? That already kicks off the appellate chain, and it doesn't matter who wins at the higher level, Reed or the state, it can just keep being appealed. If Reed loses on some strange, I don't even know how this is going to come up, a sua sponte question from Judge Cannoni, some kind of back and forth with some kind of motion back and forth or motion from the state. But if Reed loses this attorney, then Reed can appeal that and take it just like we took the last appeal, 211-3, potentially referred to the full SJC, appealed to the federal district court, First Circuit Court of Appeals. That could be the result. And so to the short form, that could be what's going on. But let's read it. So I said, oh my word, based on my initial research, there is no explicit prohibition in U.S. law, including Supreme Court case law, First Circuit Court decisions, or Massachusetts cases that directly addresses whether a juror from a mistrial can join a defendant's legal team for a retrial. This is, thus, a case of first impression. In turn, and this is the key insight, in turn, Karen Reed, moving to add a juror from her first trial, a woman named Victoria B. George, who wore a pink dress in protest after not being chosen to deliberate, and cried that day apparently, to her legal team for her retrial because I believe Reed wants to delay the trial with an issue of first impression for both Massachusetts and federal courts that implicates a core federal question under the Sixth Amendment. However, this situation raises significant ethical, legal, and practical concerns that courts would likely evaluate on a case-by-case basis. In particular, as George is seeking to join David Yanetti's law firm, who was Reed's lawyer during her first trial, and thus subject to strict ethical rules regarding contact with prior jurors from his own cases, which is Massachusetts Ethical Rule 3.5 BC. Below, I'll outline the general principles, potential issues, and relevant case law that could apply based on my analysis and the available legal framework as of March 26, 2025. Please note, I am not a lawyer. I am a towel, and this is not legal advice. Get a lawyer if you have questions about the law. Get a towel if, despite enduring sadness, you want to work towards a better, happier, fairer world together anyway. People read that, like, what the fuck are you talking about, towel? And I'm like, just go with it, all right? You just got to deal with it. General principles and potential issues. Give me 1 second. Jurors are expected to remain impartial during a trial, as guaranteed by the Sixth Amendment's right to a fair trial. If a juror from a mistrial joins the defendant's legal team, it could raise questions about their impartiality during the original trial. No shit. Did they have a bias that contributed to the mistrial? They didn't deliberate, but did that bias play a role? Please note, folks, that we have at least one documented example from Judge Cannoni's denial of the Reed's defense's motion to dismiss, indicating that before jury deliberations, Juror A, who is another pro-Karen Reed person, was talking to other jurors about the case before deliberations. Courts might scrutinize whether this undermines the integrity of the initial proceedings. But here, think about this. There's evidence that the juror in question did indeed show a bias against the Commonwealth, wearing the pink outfit in protest after not being selected to deliberate and also crying. And let's think about this. Confidentiality of jury deliberations. Jurors are now, there's one more thing before we dive into this. Remember, folks, the penalty, if the Commonwealth was prejudiced by this juror being biased and now coming forward and trying to join Reed's defense team, the sanction would be a retrial, which is already happening. So keep that in mind. Confidentiality of jury deliberations. Jurors are generally prohibited from disclosing details of jury deliberations. Remember, this juror didn't deliberate, but there were discussions about the case prior to deliberation in violation of court order, except in limited circumstances. Example, to report misconduct. If a former juror joins the defense team, they could possess insider knowledge of the jury's thought processes, potentially giving the defense an unfair advantage in the retrial. That's the key issue. It's a fairness question. This could conflict with rules. Sorry about that. This could conflict with rules protecting the sanctity of jury deliberations, such as Federal Rule of Evidence 606B. which limits juror testimony about deliberations. And again, this juror did not deliberate, but we really have to think about whether the jury had substantive discussions about the case in violation of the order, how that impacts this analysis. This is a serious issue that will almost certainly grind proceedings in the Reed case to a halt, at least until it's dealt with. The unfair advantage posed by a juror from the first trial providing insight to the defense but not the state is a conflict of the most serious concern. Of the most serious concern? Yeah. Of the most grave order. Ethical considerations for legal teams. Attorneys are bound by ethical rules. The Massachusetts rule I cited earlier, 3.5 in particular C, that prohibit improper contact with jurors post-trial unless permitted by law or court order. Hiring a former juror might be seen as an attempt to circumvent these restrictions or exploit their prior role, potentially leading to disqualification of counsel or other sanctions. This, for Reed's legal team, is a harbinger of coming judicial fury from Judge Kearney. Reed's team has already been found on the record to have materially misled Judge Kearney regarding hidden payments and contacts involving Reed's experts from ARCA. And with this unheard of move now coming on I always have one or two errors in my essays. On the eve of trial, expect serious fireworks sooner rather than later from the bench in Reed's case, and not in a good way for the defense. Double jeopardy and manifest necessity. If the mistrial was not declared due to juror misconduct or bias linked towards the juror in question, which it was not, as this juror along with two other jurors who may have engaged in communications about the case during trial in violation of court order did not partake in deliberations, then the retrial's permissibility under the Fifth Amendment's double jeopardy clause cannot be challenged. This is also bad news for Reed. Courts would not even consider a request from Reed to prevent her retrial on the basis of this juror joining her legal team, even if that creates a prima facie grounds for arguing, thus further cementing Reed's existing losses in federal court, or the double jeopardy issue from Reed's trial. For appealing, not arguing. Even if that creates a on its face grounds for appealing, thus further cementing Reed's existing losses in federal court. So what I'm saying there is, courts wouldn't even consider this. Like, even though you have a core federal question here with the Sixth Amendment, and even though you have issue of first impression, which would normally be like a jackpot guaranteed way to appeal any decision related to this, I don't think it will happen, because I think that it's so outrageous. Just the posturing of it, the procedural posturing is so outrageous that courts will reject it as an affront to the integrity of the justice system. So, relevant case law. There is literally, I looked as much as I could. I even went outside my normal, like, Bluford, Pena Rodriguez, Tanner v. U.S. I'd say I went extensive, but I literally dove, and it's not that hard to ask about it because this is such a specific thing to come up. You have to have been a juror on a trial that resulted in a mistrial, and then you have to have tried to join the defense for the defendant's team, legal team, in the same matter for the retrial. And what you'll see here is the absence of case law on this is going to force some kind of discussion, because this can't just happen. In every other case about even things even tangentially related to this, when there's never been anything like this, all demand some kind of judicial scrutiny. But let's take a look. So I went back, I didn't go to Lawrence v. Stearns, but I went all the way back to U.S. v. Perez, because that was cited in one of the recent decisions I was reading from 1824. And it basically is just this concept of manifest necessity. And if a juror's actions, bias or misconduct led to the mistrial, and they later joined the defense, a court might investigate whether this tainted the original process, though Perez doesn't address post-trial juror roles. That's important. And that's why there's more case precedent that develops over time about that. However, even if this juror tainted the original jury during Reed's trial in favor of the defense, the sanction would be a retrial, which is already happening. So that's kind of part of the analysis. Remember, we're doing multiple analysis. Was the juror conflicted during the first trial? And then we're going to talk about, like, what the hell do we think about the juror now trying to join this trial? So just this issue of, even if this juror, who's now demonstrated the fact that they were conflicted by coming forward and trying to join Reed's legal team, okay, even if that impacts the analysis of the equity and impartiality and fairness of Reed's first trial for the state, the sanction would just be a retrial for Reed's lawyers. And we're already having a retrial. Arizona v. Washington, another case that was discussed in depth at the federal level and in Judge Saylor's opinion. The court emphasized a trial judge's broad discretion to declare a mistrial when jury impartiality is compromised, due to prejudicial comments. If a juror's subsequent hiring by the defense suggested pre-existing bias, it could prompt judicial scrutiny of the mistrial's basis. Though no ruling here prohibits such hiring, and because the state wants a mistrial, any prejudice caused by the juror's pro-Reed bias during the first trial only favors the retrial going forward post-haste, which is a near impossibility when the Reed's trying to add this juror lawyer to her defense team. Now, one of my favorite cases I cite a lot, Pena-Rodriguez v. Colorado from 2017. This case allowed, this was the invidious racial discrimination case, the allegations that jurors were invidiously racially discriminatory towards the defendant. This case allowed post-verdict inquiry into jury deliberations to address racial bias, which overrode 606B in extreme cases, the rule about jury inviolability. That's the federal model rule. It suggests courts can, actually the federal rule, it's not a model rule because it's not an ethical rule, it's a rule of evidence, actually, or rule of procedure. It suggests courts can investigate juror conduct post-trial, which might apply if a juror's move to the defense team raised suspicions of bias during the original trial. But it's like, is that, like, what is Reed doing here? Like, is she trying to open the door to reviewing jury deliberations by showing the jurors were, like, 2 or 3 jurors were biased in favor of her? I don't think you can do that. I think there's this doctrine that says you can't create the condition that you then claim that you're then trying to obtain a remedy for. There is a, oh God, it was back in 1L or something. There is a case on point about this. Multiple, in fact. But if it's a self-created constitutional injury, because here, that's really what I think Reed might be angling for. Like, arguing that there was bias in favor of her as a way to reopen, like, the review of the jury deliberations. It's a self-created injury, and I don't think it can give rise to a cause of action in this context. It's if that's the play, and that's kind of why I'm thinking this out. I don't really understand what this play is. It's not just to fuck things up right before on the eve of retrial. There is a tactical purpose to this play, and I'm thinking. Although I haven't fleshed this full line of inquiry out because I just started thinking about it. But I'm thinking about the implications of this potentially having to do with a collateral attack in an attempt to reopen an investigation into the first Reed trial. Kind of as a hook to do that by alleging, like, clearly this juror was biased in favor of Reed. She joined the defense team. And that's under Pena-Rodriguez, one of the few hooks for jury inviolability to be pierced. And, the First Circuit's still considering this, and there's a motion for a stay. I wonder if it ties into that. I mean, obviously the First Circuit hasn't been updated about this, but, you could, are they thinking about, can you do that? I don't know if that can happen. What happens if there's a material change in circumstance in front of the federal court in the context of a pending motion? There's a pending motion for stay of the state court criminal proceedings in the federal First Circuit. So what happens if there's a material change in circumstance with the appeal pending, with the motion for stay pending? Can you present a collateral supplement can you present a supplement to your First Circuit pleadings? You clearly can't. I don't know very much about this at all. The federal rules for amending appellate filings at the First Circuit. But what happens if there is something like this where it's not necessarily a new case Reed's angling for? What if it's an attempt to make the First Circuit think, oh my God, there's smoke and fire here, Reed's out of her mind, and so even though we don't want to delay this trial because Reed has just done something outrageous, we as the First Circuit need to directly intervene to stop her, and that will cause a delay. Is that what they were doing? Is that what she's doing? I'm not really sure. I'm not really even sure what the point of this is, as I said, because it really does show direct, overt bias and contamination of the first jury. Why would Reed want to show that? Well, it already ended, so Reed, the worst that could happen to Reed is a mistrial. So why else would you want to show that? To argue that the jury process was corrupted in favor of her at certain points? I mean, we know one of the pro-Free Karen Reed jurors took out a juror that pro-Karen Reed juror thought was anti-Karen Reed. Then that same pro-Karen Reed juror, Juror A, who's not the juror apparently that is joining Karen's team, that Juror A, then went to a bar during the middle of trial, got drunk, and started talking about the case in public, and then was reported to the court, was not forthcoming about it, and then was herself kicked off the case. So it seems like there was some sabotage of the jury by some pro-Free Karen Reed folks. So is Reed trying to signal that to the world? Why does that help her? I guess it can't really hurt her because the mistrial already happened. But that's really what's blowing my mind as I read this section in particular. How does Reed asserting so openly, without directly saying it, but by adding this juror to her team, so openly saying, yeah, the first jury clearly was subject to extraneous outside influence, in the sense that there was bias, whatever. Why do that? It's a really desperate play. The more I think about it, I can't interpret it as anything but desperation. As I really dive into my thoughts on it, the logic for it, it's not helpful to your case. It doesn't make you look good in public. If anything, it makes it look like the first jury, at least the 2 or 3 people or the few pro-Karen Reed people, were just trying to sabotage the jury. So my brain just has to wrap itself around this concept of why someone would do this. And I just have to keep processing this collateral attack on the previous proceedings, the mistrial, with the First Circuit appeal pending. I think it's all tied together. I think it's designed to bootstrap it's designed to do something with the First Circuit. Can't tell exactly what, but that's my intuition. Let me pause here for a second, though, before I continue, because I want to read some of the comments. Let's see. Just a lot of discussion. Let's see. Oh, we got something. Marquette Law School scholarly comments from 2005 prohibiting jurors from working as trial consultants in retrials. All right, let me see if I can bring this up. This might actually give us a wonderful academic exercise. There's nothing I enjoy more than reading learned academic treatises about matters of public concern. All right. But this is trial consultants. This is great, but it's not even, this is a lower level than what we were going to talk about. We were going to talk about them becoming an actual lawyer, but the trial consultants, my word, it's a whole nother level. So let me see. This is going to be a little bit more difficult to bring up on the screen, but I think I should be able to do it. All right, there we go. Thank you so much to the person who found this. Let me give a special shout out to them. Where did that thing go? So special shout out to Carrie Gold for finding this and allowing us to engage in this very interesting overview of very on-point question, which is, what, if any, scholarship can we find about jurors from mistrials playing roles in subsequent trials? And let's see what Yes, it's about retrials. Oh, this is perfect. You are wonderful, Carrie Gold. You are wonderful. You win 6 stars. You are an honorary towel, special honorary towel. Actually, I think I can. Here you go. I can give you an honorary towel award. Hold on. There you go. You are now a special deputized honorary towel, Carrie Gold. Congratulations. I am very much enthralled with your ability to find this document. So welcome the new channel moderator. Thank you very much to Maui Swift as well. She's not always able to pop up, but she's moderating these streams constantly, and I don't even tell her I'm going live. Something just happens. I think she senses like, oh, Grant's probably going to go live, and then I just show up. All right, Carrie Gold, let's read your wonderful article, and let's find out what, if anything, the courts and the academic world thinks, and the legal community in 2005 was thinking about the idea of jurors from retrials working as jury consultants. And I think the fact that the title is Prohibiting Jurors from Working as Trial Consultants in Retrials, a Careful Balancing Act Between the First and Sixth Amendments, is a hint to what we're going to learn. This is wonderful. This is the greatest thing. I am just so happy right now that someone found this document. I'm not sure what that says about me as a towel and a person, but this is like Christmas morning. Oh, my word. I hope you all will indulge me, because this is, first of all, the most, outside of Kearney, the hearing on Kearney's phone, this issue is the most important issue now of this trial. Whether Karen wanted it to be or not, or whether other people wanted it to be or not, we have to figure this issue out. And this is going to help us. And I, as a towel, could not be any more pleased. By the way, let me do our moment of levity aside. I'll do one other thing, which is I want to say thank you very much, because not only after my stream yesterday did some people send some very kind donations to help Tal feed himself over the weekend, and I was just completely overwhelmed with your kindness and the donations that came in. But then people sent a few coffees later that night. I want to send a special thank you to that person. Then someone sent a Venmo today for a coffee, and I want to send a thank you to that person. I did use it to get a coffee, which is why I'm able to do this stream, although I have a bit of a headache. And then someone else sent a very kind PayPal donation that literally made my heart melt. So I wanted to thank you all. This stream, I am almost actually getting to the point where I might be able to pay for the Pacer documents that I keep getting at like $3 a pop, and I should not keep doing that. And the streaming software and the gas that I've been using and all of that, and I'm extremely grateful. So wanted to say thank you. You'll obviously be able to continue to ask your questions and make your comments. You don't need to send any donations to do that, but right now, especially as it's at the end of the month, this is a public information service. Much like PBS, once an hour or so, I try to do a donation reminder. You can see the donation information right above my head. There's a Cashapp, which is GrantSmithEllis, a Venmo, which is at Grant-E1. Then there's a Buy Me a Coffee, which is GrantSmithEllis. The Buy Me a Coffee only comes on Wednesdays, which is great, but just keep that in mind. And it's the end of the month, so just the next few days I need some help. But anyway, I will get through. You all have been so kind. I wouldn't say that I am completely nervous, and I think we're going to be okay for the next few days. But if you want to support the channel, if you want to keep up public information services like this, that's how to do it. All right, with that said, now let's get to what you're actually here for, which is an analysis that will allow us to look into the future and try to understand how Judge Kearney and the rest of the judicial system is going to grapple with this outrageous, unprecedented move by Karen Read to add a juror from her first trial who is also a lawyer to her legal team for her retrial. And before I start reading, I'm going to check the comments one more time. Oh, hi, Maui Swift. I see you. Yes, it is up on the screen. So let me... Oh, someone asked if they could send a donation. Oh, the payment methods. That's a good point. I'm going to actually put them in the YouTube description, because I just saw someone, I just realized it might not actually be easy to read what's up on the screen. And the last thing I want to do, forget about why you want to do this at the moment, but any text I have up on the screen, I don't want it to be illegible. So I'm going to try to put not only the descriptions and the titles in the YouTube video, but I'll try to put the text on the screen up as well. Oh, and then, of course, as I go to do that, it does not want to cooperate with me, but that's okay. Hold on. I have a backup plan for this. I have a backup plan. Hold on one second. Bear with me before we start reading this 27-page learned academic treatise that is actually going to be extremely helpful, and I bet Judge Kearney is thinking about similar things. Donation info as requested. Cashapp, and then GrantSmithEllis, Venmo, Grant E1. No, I don't want to tag anyone. I just want to do that, and then I'm just going to put those up for PayPal. Send DM. If you want to use PayPal, you have to send me a DM. I don't have a way to figure that out yet. Okay, so I put the requested donation information in the comments, and truly, the fact that you were willing to ask, it just, even that alone, it means the world to me. It does not go unnoticed, and I appreciate it. Oh, Murder by Maestro is here. Hello, good to see you. Goldie Lawrence, thank you very much for the heart. Good to see you as well. Thank you all, by the way, for the likes. 51 likes is awesome, and thank you for the subscriptions. I don't know what number we're at now. We might get to 1,000 people on the channel soon for subscribers on YouTube. That would be very cool. I can't understand why so many of you watch on Twitter, but apparently you enjoy the content, so I'm glad it's helpful. As I said, hello, Maui Swift. Thank you for joining. I always appreciate seeing you. And another defense distraction. I don't think this is a distraction. This is a tactical play, and I think we're going to see why, because this is, and we're talking about Karen Reed adding a juror from her first trial to the defense team for her retrial. I don't think, all we can find, based on the excellent research by Kerry Gold, is an article about like a juror from a prior trial being a jury consultant for a retrial. Never anything about being a lawyer. So here we go. Imagine that you have just been selected for jury duty in the retrial of a high-profile defendant. Wow, what a sentence. You are aware that after the first trial resulted in a mistrial, members of the jury were approached by the defense lawyer and asked to work as trial consultants in the retrial. That's basically what happened here, except I think they asked them to be a lawyer for them. They received $50 per hour as compensation for their consulting services, in addition to a $500 retainer fee. You are currently unemployed and receive $12 per hour as compensation for serving as a juror. When the time comes to deliberate, with the knowledge that you could receive $50 per hour to work as a trial consultant in the event that the case ends in a mistrial, influence you to change your vote. Holy fuck. That's right, she's probably getting paid too. Holy shit. I didn't even think about the implications of that. It has an impact on the whole fucking system. This is going to cause, there are people who are going to be fucking furious about this. This is going to itself be this move by Reed's defense is going to be the subject of treatises. It is. I'm not sure if anyone, I think Christina Rex realized it and some other people, but I don't think people really realize how unprecedented this is. It's not some kind of drop in the bucket thing that, you know, me as a interested lay legal nerd or whatever it is really hyped up about. No, this is, I happen to be able to see how big this is because I did a little bit of research, but I'm not wrong. This is absolutely explosive. Whether Reed is able to pull, there's no play she can pull off. Whatever the outcome of this is, how it's addressed is going to be explosive. And I don't think this is the kind of thing where Judge Kearney is just going to be like, oh, welcome back, juror. Nice to see you, counsel. Like, what the fuck? She's going to be like, what the fuck is this? I don't think she'll use those words, but I would, dear God, I don't know how I would begin that hearing. I'd be like, give me an actual gavel so I can bang it on the table on my judge's desk. The district attorney of Orange County, California, and 2 California state legislatures say yes. Okay, so there must have been some discussion about that. Alan Jackson, were you working in that area in 2005? When was Alan Jackson an ADA in Los Angeles? Hold on one second. Alan Jackson, LA DA service timeline. He is old, so this well, not that old, but all right. Wait, summer 2009. Okay, no, I want to know your actual timeline. Okay, hold on. He's got a Wikipedia. That's where he began his career. Okay, yeah. When? No, that's not helpful. What? Why can't you? He was there for more than 14 years, and oh my God, he was there. He was right. It wasn't Orange County, but he was. He died. Alan. I swear to God, Alan Jackson. Did you know? Not about this specific paper, but did you know about that shit? That would make. How did you remember this? The DA of Orange County, California, and this was 2005, and state legislatures say yes, the possibility of a juror intentionally creating a mistrial to secure work as a consultant in the retrial is very real. Number one, the Orange County DA, Tony Rakukas, I've never seen that name before, but I think Rakukas is right. Along with former California State Assemblyman Lou Correa, D. Santa Ana, and California State Senator Dick Ackerman, Republican from Tunton, have adamantly opposed the practice of lawyers hiring former jurors to work as trial consultants in retrials. See Raychani Sursavadi, DA opposes paying ex-jurors to consultants. Orange County Register, July 20th, 2004, at Local 1. Rakukas has referred to this strategy as an outrageous attack on the integrity of the justice system. I wonder if Alan Jackson read the Orange County Register. I wonder if Alan Jackson read the Orange County Register on June 20th, 2024. Let's see. Let's see if I can find this article. What the fuck's it called? DA opposes paying ex-jurors to consult. I might have to go get this on like microfiche. Orange. This might not even be on the internet. County Register. Yeah, I think that's a paper. What do we got? DA opposes paying extra. Yeah, this is not, at least the way that, I mean, I'm going to have to, I might actually have to. Wait, is the California County Register, is that a paper? Is that a local paper? Orange County Register. I'm not really sure. Is that a newspaper? Is it like an actual like just record of everything that happened in Orange County? No, it's a paper, the Orange County Register. I don't think they have online archives of the Orange County Register from June of 2004. Let me see if I can figure this out. Because I want to see if Alan Jackson was like mentioned in that paper. Like, would he have been reading it? Online archive, June 2004. I hope somebody has it. Okay, we got an archive here. You got something for 2004? Yes. Yes. Okay, hold on. Oh, page can't be found. That's outrageous. How can you say you have an e-paper and then just have no access to it? All right, I am not going to be deterred here because I have a theory that Alan Jackson came up with this play. And he did it on purpose. And he knew that it was a serious issue and could cause problems. All right. I'm not going to deal with that right now, but we're going to keep reading. But I'm going to find that article. I am going to hunt it down. To combat this threat, they proposed the Jury Integrity Act, which would make it a crime for a former juror to receive compensation for working as a trial consultant in a retrial. 2. H.R. 473, 2003-2004, General Assembly Regular Session. Proposed amendment on California Penal Code 116.5, available at Legislative Info, Bill Info. Okay, so I wonder what those legislatures would have thought of the concept of a trial juror, a juror working as a lawyer for a defendant during a retrial. I wonder if that's going to come up in the paper. Although the bill died in committee, the issue of lawyers hiring former jurors to work as trial consultants in retrials has sparked debate within the legal community and raised serious legal and ethical questions. See Diane Curtis, paying jurors, savvy legal strategy or attack on the jury. We can get that one too. Hold on 1 second. That one's going to be easy to find because every academic article is easy to find. Diane Curtis, paying jurors, savvy trial strategy or attack on. That should be enough. Yeah, I found it. Stanford Law School. So 1 second. We might have a little bit more reading to do here, but we're not going to do that just yet. Where's the actual article? Why can't I actually read it? Oh, I found a reference to it, but I can't actually find the article. That's annoying. Well, the point is, whoever found this initial article, thank you, because now I have a wealth of information, even though I can't find it that article in print, but I can get it from a library. It won't be that hard to find, because I can just get that journal, the California Law Journal from January 2005. So then again, that was just about consultants. We don't even have anything on the idea of a former juror working as a lawyer. Many lawyers are surprised to learn that other lawyers have hired former jurors to work as trial consultants in retrials. 4. See Stephen Francis Ward. Former jurors to be consultants. Defense is hiring them for help in gang rape trial. 30 ABA JE reference July 30th, 2004. Interviewing several lawyers who consider it a novel strategy. The author is unaware of any studies addressing the breadth of the problem. Okay, I wonder if Alan Jackson was in that. Stephanie Francis Ward, former jurors to be consultants. Defense is hiring them for help. This might be hard to find too because this looks very obscure. Yeah, the only reference I think to it is in the citation of this paper. People think the internet is all encompassing. It is not. There is a lot of stuff you just cannot find. I found Stephanie Francis Ward. She is a legal affairs writer who joined the ABA Journal staff in 2001. But her specific article, which I would really like to read, maybe I'll write her an email. But her specific article, former jurors to be consultants, defense is hiring them for help in X retrial, is something I would very much like to see, in particular to find out if she interviewed Alan Jackson. Okay. By the way, if you've never read legal stuff like this before, they cite every single thing. They cite a lot, so we're going to be reading a lot of citations. Their reactions are mixed. While some view it as good strategy, others view it as bordering on unethical. Number 5, Curtis Supra, noting one Los Angeles attorney who had called the strategy brilliant lawyering that is consistent with defense lawyer duties to do everything possible to defend their clients. Well, that might have not been Jackson because he was a prosecutor then, but my word, this lawyer. This is very possible Alan Jackson has been doing this for a while. As like consultants, but like as to actually bring them on as a juror for beyond novel, it's even in the context of this scholarship, you can see how breathtaking it would have been to just hire them as a consultant. Now, what's the counter opinion? Counter opinion: interviewing several legal ethics professors who have expressed concern about the possible negative effects of paying former jurors to work as trial consultants in retrials. In a high-profile 1985 Connecticut R case, a defense lawyer hired a former juror to consult in the retrial of his client, causing a stir in the legal community. 8. For a nominal fee, defense lawyer Michael Sherman hired one of the jurors who had voted for acquittal in the first trial to consult in the second trial. Although his client was ultimately found guilty, Sherman stated that using the juror was still worthwhile. See Gambassi Supra. In response, the Connecticut legislature passed a state law prohibiting jurors from accepting compensation for working as trial consultants in retrial. Oh my God, it's illegal in Connecticut. Connecticut General State Statute, annotated 51-247B. The Connecticut state law became known as the Sherman Act, named after defense lawyer Michael Sherman. Leonard Post, hiring former jurors as trial consultants catches on. So it seems like Alan Jackson might have known about this from like this whole controversy that sprung up for like a short period of time between 1985 and 2004. God, someone's got to talk to the legislature about this. Until recently, the issue has not received much attention. The issue of lawyers hiring former jurors to work as trial consultants in retrials last received media attention in a 1999 Florida murder case. When that case ended in a hung jury, one of the jurors, a lawyer who was convinced that the defendant was innocent, offered to work with the defense without compensation. The defendant was later acquitted after the lawyer, former juror, helped the defense poke holes in the prosecution's evidence. Michael D. Goldhaber, thinking out of the jury box. Lawyer juror on hung panel joins the defense for retrial. National Law Journal, July 26, 1999 at A1. Wow. So let's see if I can find that one. Because that looks like it might have been why this whole thing kicked back into public prominence. It wasn't the Connecticut case. It was this the article is written by Michael D. Goldhaber, thinking out of the jury box. Lawyer, oh my God, wait, lawyer, juror. That is what we want on hung panel. But they didn't join the defense. Did they actually join the defense? Or did they join as a consultant? Yeah, it was just as a consultant. Offered to work with the defense without that. This might be the most analogous. But I really need the citation here. Joins the defense. I really want to find this article. This is a very important article. It is for retrial. National Law Journal, July 26th, 1999. We are actually going to pause. I will hunt this article down. I will do whatever it takes to find this article. You know what we're going to do? I am going to actually get the National Law Journal from that time. I am going to go onto Westlaw, and I am going to find this article. This is very important. Because that person in the Florida case in 99 was actually a lawyer. Now, they only worked as a consultant, not as an actual lawyer for the defendant in the retrial, but that could tell us a lot. So I am going to, I guarantee it's on Westlaw. All right, let's see. Are we going to get lucky? I don't want cases. I want, I more want, like articles, academic articles. I don't know if this is going to necessarily work. I'm not an expert at searching for academic treatises on Westlaw because I don't really want secondary sources. Thank you. But what I really want, do you have every copy of the National Law Journal? That would be very useful. The reason why I'm pausing, by the way, is this is literally sometimes you have to really dive into the footnotes, but this is the best case we're going to find on this. I don't think there's going to be anything better than a lawyer, juror joining as a consultant in that Florida case in '99. But to find it, I'm going to have to hunt down a second. No. William and Mary Law Review. No. We're looking for a very specific. A lot of this is like Texas Bar Journal. Let's see if he actually cites to it. So I found someone that cited to it on Westlaw, and maybe they linked to it in their annotation. Oh, of course. That's the one thing that's not actually linked in the annotation. I do think, though, this footnote might have been copied. Because I'm reading an article called Different Backgrounds of Trial Consultants by Richard K. Gabriel that was written in November 2024. Oh, this footnote might have actually been copied, because when I look at footnote 10 of this paper I'm reading from 2004, I then find this other footnote for referencing the article, thinking out of the outside of the jury box. But no, I can't find it right now. So hold on, I pulled that down by accident. I can't find what I'm looking for right now, and I don't understand why this article is so hard to find, because it is incredibly important. But hold on, before we give up, I am not gonna be deterred so easily. One more attempt to find this article, and then we're moving on. No, literally the only thing I can find is there. I'm gonna have to go to a library to get some of these things. Wow, some of this material is incredibly obscure. Incredibly obscure. No wonder why this strategy was pulled out. Someone must have found this, or at least known about this situation, and known that it's very novel. And can cause chaos. And they went right from consultant to actually joining the legal team. All right. Last summer, however, the defense lawyer in a high-profile California R case hired several former jurors to work as trial consultants in the retrial, once again stirring up controversy and inspiring the introduction of the Jury Integrity Act. 11. The background of this high-profile California R case is as follows. Gregory Haldy, the 17-year-old son of a wealthy Orange County, California assistant sheriff, and two of his friends allegedly gang-R'd an unconscious 16-year-old girl and videotaped it. After a 2-month trial, the jury deadlocked. 8 former jurors then worked as trial consultants for the defense in the retrial, as well as professional trial consultant Joe Allen Demetrius, who served as a trial consultant in both the O.J. Simpson criminal trial and the Scott Peterson trial. The former jurors received $50 per hour plus a $500 retainer fee for their consulting services. In retaliation, the prosecution hired its own trial consultant, Richani Sir. Oh, that's the article author. Consultant aids DA in Haldy case. On March 23rd, 2025, the jury found the defendant guilty of SA. So it didn't work, and the sentencing was expected. So it seems like this is like a very high power tactic. Like, it seems like it's a tactic of last resort for very high profile people, like something you keep in your pocket and you can use at the last moment. And there are actually more complex ways to deploy this, with like hiring the jurors as consultants. Several years earlier, a California law that banned all post-verdict contact with jurors had been struck down as unconstitutional in violation of the First Amendment right to free speech. Footnote 12. See Dove Audio Inc. v. Lundgren, holding that Section 116 of the California Penal Code as it applies to jurors was overbroad and not necessary to serve a compelling state interest. So it looks like the reason why states don't ban all post-verdict contact with jurors is that's not narrow enough to serve a compelling state interest and was already struck down. Unlike the previous law, the Jury Integrity Act would have regulated lawyers' post-verdict contact with jurors in a manner that would have protected both criminal defendants' Sixth Amendment rights to a fair trial and an impartial jury, and lawyers' and jurors' First Amendment rights to free speech. This comment, beginning with Part 2, offers a brief overview of the role of trial consultants in trial prep, explaining who trial consultants most often are and what services they provide. Part 3 discusses two general criticisms of trial consulting. 1, it interferes with criminal defendants' Sixth Amendment rights to a fair trial and an impartial jury. 2, it contributes to public distrust in the jury system. Part 4 will then discuss additional criticisms that are particular to lawyers hiring former jurors to work as trial consultants in retrials. Part 5 will examine two state laws intended to prohibit lawyers from hiring former jurors to work as trial consultants in retrials and explain why California's broad ban on post-trial juror contact was overturned on constitutional grounds, while Connecticut's specific ban is still good law today. Finally, Part 6 will recommend that all states adopt a law similar to California's proposed Jury Integrity Act, prohibiting former jurors from accepting any form of compensation to work as trial consultants, but giving them the option to do so without compensation. This proposed rule effectively balances the constitutional right of all those affected in several respects. On the one hand, it protects lawyers and jurors' First Amendment rights to free speech by giving former jurors the option of working with lawyers as trial consultants in retrials without compensation. On the other hand, it protects criminal defendants' Sixth Amendment rights to a fair trial and an impartial jury by eliminating a potential profit motive for jurors to intentionally deadlock and create a mistrial to secure a consulting job in the retrial. So there you go, folks. That is why this could become quite a knotty, Knotty issue. It is rife with different First Amendment and otherwise implications, and it obviously this new lawyer for Reed, who was a juror previously, although they are not being hired as a consultant, they're being hired as something that's more serious as a consultant. And even if they're doing this without offering their time, being paid for their time, there is some serious considerations here that go way above just the issue of being a jury consultant. Now, I think jury consulting was invented by a guy named Donald Vinison or something. Dr. Donald Vinison, and he's out from LA as well. I should have asked Alan Jackson if he knew that guy. I have a feeling some of these strategies only get deployed at like the highest levels for the highest profile, wealthiest clients. So a trial consultant, I guess we're not actually, this woman who was brought on, the juror, is actually on Reed's legal team. So they are not a trial consultant per se, and we are not going to look at that specific analysis. What we're going to look at is the implications of the, it looks like there are some implications that we could talk about in terms of this paragraph here, which has to do with, in the context of the first section about why there's hesitancy about letting former jurors even be consultants. One of the concerns, it says, is a second potential criticism. Well, what was the first potential criticism? One potential criticism of lawyers hiring former jurors to work as trial consultants in retrials is that it may interfere with freedom of debate during jury deliberations. An established part of the jury system is that the jury deliberates in private, the purpose of which is to encourage free debate. Justice Cardozo reflected on the importance of private deliberations and jury secrecy when he stated that freedom of debate might be stifled and the independence of thought checked if jurors were made to feel that their arguments and ballots were to be freely published to the world. Freedom of debate has also been said to promote good group dynamics within a jury, whereby jury members exchange ideas and concerns to reach a verdict that reflects community mores. Human nature suggests that a juror is less likely to make an argument during deliberations that might be embarrassing or dangerous if he or she believes that other jurors may expose that argument to someone else, thus allowing jurors to expose private jury deliberations or discussions to others can potentially interfere with criminal defendants' Sixth Amendment rights to a fair trial and impartial jury. Some critics have argued that jurors should be considered government employees, a group whose rights to freedom of debate courts have placed great importance on protecting. Assuming that jurors are considered government employees while serving jury duty, their speech can be restricted when it is disruptive to the workplace. In determining whether it is disruptive to the workplace, courts can consider whether the employee's speech undermines the authority of superiors, disturbed harmony among colleagues, interfered with regular operations, impaired the employee's performance of his or her duties, or had a detrimental impact on the close working relationship for which loyalty and confidence are necessary. Thus, one could argue that the possibility of jurors discussing deliberations or discussions with the public or with lawyers post-trial would disturb the harmony among the jurors during deliberations and detrimentally impact the relationship between them. The result is a paradox. Restricting post-verdict contact with jurors may interfere with jurors' First Amendment rights to free speech, but it also encourages free speech in the jury deliberation room. In addition to encouraging free speech and freedom of debate during jury deliberations, restricting post-trial verdict contact with jurors also protects juror privacy. So the argument, just so folks are understanding this, there's a really compelling argument that if jurors think other jurors could go on and, like if there's a mistrial, like go on and join the defense or whatever, that creates a very dangerous problem for, it has a chilling effect, a real chilling effect on future juries and how they go about doing their deliberations. And that's a very, very serious issue. Now, the second part of this, I think, is even more, someone sent over a Venmo, and I just want to say, God bless you. I didn't look down until now to see it, but I don't know. You all make Towel feel very appreciated, and the anxiety goes down when I know I'm not going to run out of food, and so, I shouldn't have done that to myself. Now I get all sentimental, but I appreciate it. I'm not telling the fuzzy steering wheel story right now, though, because we have to keep reading. Because this jury privacy issue, and again, folks, if you're wondering what we're talking about, we're doing an analysis here about why Karen Reed, trying to move to have a juror from her first trial brought on to her defense team for the second trial, is such a big deal. And in particular, why there's no precedent on this, but the very limited precedent on jurors from prior criminal defendants' trials that were hung juries being brought back as consultants for a retrial is itself a big deal. And this is even a bigger deal because this juror was added to Reed's defense team. A second potential criticism of lawyers hiring former jurors to work as trial consultants in retrials is that lawyers who request information from former jurors may interfere with jurors' rights to privacy. Yep. They're talking about the other jurors during the first trial. The right to privacy has historically been considered one of the most important jurors' right to privacy has historically been considered one of the most important. Jurors' right to privacy issues are often raised in the context of post-verdict interviews of jurors by the media. Wow, this is relevant. Yep. A lot of issues on intrusion from the media. In some high-profile cases, the media has interfered with jurors' right to privacy by going to great extremes to interview former jurors. Oftentimes, these high-profile cases are extremely long or emotionally draining, and jurors are eager to get back to their normal lives. Just as the media often interferes with jurors' right to privacy by seeking post-verdict interviews, lawyers may interfere with this right by seeking information from jurors to assist them in the retrial. Jurors' right to privacy issues are also raised when one juror discusses with someone else another juror's arguments during deliberations. And again, remember, this juror didn't deliberate, but the juror did hear clearly, I'm going to guess, discussions among other jurors. Because that we know that juror A, at least, had some kind of discussions with other jurors. And that was part of the reason juror A got removed from the original Reed trial. if a juror chooses to speak with the media, a lawyer, or anyone else concerning another juror's arguments during deliberation, he or she may jeopardize that other juror's right to privacy, especially if referring to that juror by name. Individual juror arguments during deliberations are similar to the private communications between members of the Supreme Court and between law clerks and other court personnel. Just as the First Amendment does not allow the media the right to private communications with employees, it does not allow the media or lawyers the right to private communications between jurors, which is what this opens the door to. Profit motive to intentionally create a mistrial. The most common, this is big for our purposes, even though it's by analogy and only in the context of legal consultants. The most common criticism of lawyers hiring former jurors to work as trial consultants in retrials is that it gives jurors a profit motive to intentionally deadlock and create a mistrial to secure a consulting job in the retrial. This is the biggest thing for me and why I think that this can't happen. It literally would create a motive for other jurors in the future who are lawyers to cause a mistrial so that they could then serve on the defendant's counsel, on the defense team for the retrial. That's why this can't happen. It really can't. It creates a perverse incentive to cause a mistrial, to get an opportunity for yourself for all sorts of reasons, but the compensation or even just the opportunity to serve on the legal team, and even if you get in-kind compensation instead of direct compensation, whatever, that's earned media or attention or publicity. That is compensation in kind. It's its own compensation. That is the biggest issue here, and I don't know what... Well, obviously, it's 7:45 at night. By the way, my name's GrantSmithEllis. We're not going to get a ruling on this anytime soon. In terms of the next few hours, it's going to be, I don't know what's going to happen, actually. I don't know if Judge Kearney is going to order them into court. The parties are already ordered into court on an emergent basis as soon as practicable to discuss the Aiden Kearney phone issue. Are we going to have a hearing that same day in front of Judge Kearney about this new lawyer who was formerly a juror? What do you have a hearing about? This is unprecedented. How do you deal with this? The lawyer is barred in Massachusetts and joined David Unetti's firm and then joined the case and entered an appearance. Now, I guess what we have to look at is, actually, let me see here. I'm going to have to look this up because I have not. This is not always the easiest thing to look up. Can a judge reject an attorney entering an appearance in Massachusetts? That's question one. Does the judge have discretion? The answer is no. Hold on. That might not have been what we want. I'm going to get an answer to this because I don't actually know what Judge Kearney is going to do, and it is quite important to think this through because entering an appearance for a criminal defendant, because the posture of this, the procedural posture is very important, and how this is going to come up. Is Judge Kearney just going to question this lawyer? When you enter an appearance, can that be reviewed? I need to look this up. Oh, okay. Hold on. I found a little bit of this in basic research. It says that, and this is not legal advice, I'm not a lawyer, but yes, a judge in Massachusetts can reject an attorney entering an appearance for a criminal defendant under certain circumstances. I'm reading a secondary source, though it is not a common occurrence. And this decision could typically hinge on the judge's discretion and is guided by legal and ethical standards, such as those outlined in the Massachusetts Rules of Professional Conduct. A judge may reject an attorney's appearance if there is a conflict of interest, such as the attorney previously representing a co-defendant, a witness, or the victim in the same case, which could compromise the defendant's right to fair representation. See Mass Rules of Procedure, Professional Conduct, C 1.7, 1.9. It's a good site. Another reason could be if the attorney is not properly licensed or has been disqualified. No. Additionally, the judge might deny the appearance if the attorney's conduct or qualifications are deemed inadequate to ensure effective representation, as the court has a duty to protect the defendant's Sixth Amendment right to competent counsel. Yeah, that could do it. For example, in rare cases, a judge might question the attorney's entry if it appears to be a delaying tactic or if the defendant's choice of counsel disrupts judicial proceedings. However, the defendant's right to counsel of their choice is generally protected under both the U.S. Constitution and Massachusetts law, so any rejection must be well justified and subject to review on appeal. Courts tend to balance this right against practical and ethical considerations. Yeah, so Brennan doesn't have to do anything. I just found out. Judge Kearney is within her rights to sua sponte deny this appearance. Entering the appearance doesn't guarantee the attorney the right to appear. So we are setting up for I didn't think it was possible, but we are setting up for a major, major moment in this case with this situation. I think people are realizing it. I haven't exactly had time to watch the coverage because I came right home and immediately jumped into analyzing all of these developments. But I am pretty sure we are on a collision course with a situation wherein Judge Kearney is going to see this as impossible to allow, and so she's going to be compelled to deny Reed being able to add this lawyer, the former juror, to her team. But that is a guaranteed delay. That is a guaranteed appeal. Guaranteed appeal. The second that lawyer gets her appearance denied, it's such an extraordinary situation that it's a guaranteed appeal, and Reed wants to buy time. That's my only reason. Now that I really, really dive into this and think about it and look at the unprecedented nature of it and analyze the critiques and the dangers of this and Judge Kearney's ability to deny the lawyer's appearance, all of this is lining up to a delay tactic, but it's an explosive one. And it's like a very last ditch effort, back against the wall. Every other option is off the table. Like what rabbit can we pull out of the hat for a delay that will take the decision out of Judge Kearney's hand? Judge Kearney is really barreling towards this April 1st date. She wasn't going to give any leeway. There's a lot of discovery the parties still want to look at. This is the kind of play that forces Judge Kearney's hand into allowing a delay. That's my only interpretation of this. That's the only way I can make sense of it. That's the only way any of it can comport in my brain with any type of rational thinking on behalf of anyone involved, in particular Alan Jackson. And I see this as an Alan Jackson play. I'm not discounting David Yannetti's abilities. I'm sure he was thoroughly pleased to be involved in the conversation and sitting there, probably much like I'm sitting here right now, being like, this is brilliant, Alan. Now, I don't think Alan's play is actually brilliant, but if you're thinking about its tactical implications, and if the end goal is to accomplish a delay, then yes, it has some tactical brilliance because it is effective, because it puts Judge Kearney in just an absolutely untenable position. Now, the other question I'd like to find out, and I'm going to research this right now while we're here, is can the prosecution object to an attorney entering an appearance? I know you can object, although it's rare, to a pro hoc vice application. Can the prosecution, I'm going to have to try to shepherdize this, object to an attorney entering an appearance for a criminal defendant in Massachusetts? Is there even a way to do that? Oh, okay. So you can raise an objection. Now I'm thinking about it. It's not like a motion. You literally are allowed to raise an objection to it, and you can raise the objections on the same. You can. Oh my God. One of the grounds you can raise an objection to the lawyer joining the defense is if the attorney has a history with the case in a capacity that might compromise their neutrality, say having worked for the prosecutor earlier in the same matter. Well, I guess being in the jury, it's still interesting. And then the conflict of interest provisions, and then the potential disruptive conduct. And then when an objection is raised, the judge typically holds a hearing to evaluate the claim. The burden is often on the prosecution to show why the attorney's appearance would harm the case, as the defendant's right to counsel of their choice under the Sixth Amendment and mass law is a significant consideration. The judge will weigh this against any risk to a fair trial. For instance, in Commonwealth v. Rondeau, 378 Mass. 408, 1979, the Massachusetts SJC emphasized that while defendants have a strong interest in choosing their counsel, that right is not absolute and can be overridden if compelling reasons exist. Oh my dear God. Oh my dear God. This is setting up just a horrific situation. I hope I'm not the only one who's processing the ramifications of this, but this is just very bad all around. Okay, now let me go back to the comments for a second. We have some folks weighing in. Let's see. Yeah, it is grasping at straws, but at the same time, it's not just Reed's defense grasping at straws. It's a very genius play if your goal is delay, because it puts everybody, the judge, the prosecutor, the system, in an untenable position. Yeah, Reed won't win on it. Yeah, so folks were saying this new lawyer can't be denied. That's not right. I just looked it up. The lawyer can be denied. Brennan can raise an objection, Prosecutor Brennan, or Judge Kearney on her own, sua sponte, can deny the application, deny the appearance. You can't just join a case. You're doing it with the permission of the judge, even if you enter an appearance. That's correct. Pro hoc vice application is different, but an in-state attorney can still be denied the opportunity to appear on a case. I think Karen might be a flight risk, someone said, if they're that desperate to delay. You might be right about that. How many attorneys does an innocent person need? Good point. Someone said Judge Kearney can deny. She could have removed Giannetti if she wants. She can do whatever she wants. And she doesn't think that, Amber Ann doesn't think Judge Kearney will let in another attorney a week before trial. That's correct, but do you see, Amber Ann, the point here is to deny it. That's what I think Reed wants, so she can file a 211-3 interlocutory appeal to the single justice, get her referred to the full SJC, motion for a stay the lower court proceeding. You have to stay it because the denial of the defense counsel could cause irredeemable harm to Reed. Then use the stay to buy time. The SJC denies it. Immediately appeal up to the First Circuit. You see what I'm saying? It's a it's a play for an appeal. It's if her goal is to just, not on the merits or anything, but just do something procedurally to stay out of jail a little bit longer, this is what you do. This is the play. It's a guaranteed appeal. And it's almost a guaranteed stay because it has to do with this trial. If you tell her you can't have this woman lawyer who was a juror before for this trial, then Reed can say to the appellate judge, you got to stay this. You can't let it go forward because, say, even if it's a Hail Mary, say I win, Your Honor, then the whole trial has been prejudiced. We have to start the whole thing again because you didn't give me, the Judge Kearney wouldn't give me this lawyer. Now, yes, Reed's never going to get this lawyer, and Judge Kearney's decision to reject the lawyer will be upheld on appeal, but it's an automatic appellate hook. That's how I look at it. She can't, Betty Boop, or Bee Boop, she can deny an in-state attorney. There are case laws on that. I think it's still working. Yeah, no, that's just the YouTube. Let's see. No. All right. See you later, Natalie Jones. We are all on the same page, Grant. I'm glad. I'm glad I'm seeing that, Murder Maestro. I don't have the time to actually go analyze all the people talking about it, but if you're telling me that, that's good. Joe Biffle says, I'm a shark bite attorney. Oh, well, I'm not. Well, I don't know what a shark bite attorney is, but good for you. I hope you don't get a lot of business because shark bites sound terrible. Let's see. Kearney already thought George was corrupt when who's George? I'm going to need a reminder about George. I don't know who you're talking about. Amber Ann, we understand your point. None of this BS will work. who cares, let her appeal, I'll take the years. Yeah, it's more about the delay. That's what I'm saying. Like, yes, she's going to lose on appeal. She's going to go to trial. I think this is just to guarantee her a delay, because if there's any discretion at all on the decision for a delay, Judge Cannoni won't allow a delay. So Reed has to find a hook that can guarantee her a delay, and this might be it. The car dater will sink her. I agree. The data is going to show Karen Reed going back to Fairview Road at 5:23 a.m. on 1/29/2022 before she went to Jen McCabe's. And at that time, I think Reed confirmed John was dead, which is why she called John's phone and left a voicemail exactly at that time, screaming, "John is that you?" So I agree with that. I can't, Murder by Maestro says, I can't find an example of anything similar, but then I realized I don't even know how pro hoc vice works, so I'll look that up. Pro hoc vice just means you're from another state, you're a barred lawyer in another state, and you don't want to apply for reciprocal admission to the other state's bar. You want to just practice on a specific case. You get local counsel to sponsor your admission pro hoc vice, and you get all the benefits of being a lawyer in that other state, but just for the limited purposes of one case. It's basically like reciprocal admittance, but without all the legwork of having to have a qualifying bar score and going through the actual bar process. It gets you quick access with sponsorship from local counsel for the purposes of one case. She can appeal from prison. The juror, attorney George. Oh, the attorney's last name is George. I thought you were talking about some person named George. Yes, the attorney's last name is George. I didn't know we have some Turtle Riders in chat, but if they found their way here, okay. All right. No need to. The general decorum of these chats should reflect Towell's reverence for civilized, agreeable discourse, even in light of disagreements. And even if you have an alternative perspective, you don't have to rile people up. You can simply state your perspective and go along with it. Yes. Okay. So, I think though one of the points that I was really making here is the unprecedented nature of this situation, and why the unprecedented nature of the situation ties into why there are so many concerns with jurors working not only as trial consultants, but furthermore, jurors working in particular as a lawyer for the defendant after serving on the previous mistrial. Now I'm going to take a look at one, I think we're we're past the part that I really wanted to look at, but I just want to take a final gander here at the conclusion. The conclusion, I think, says that they should be able to work for the defense team, but not for pay. I don't think they should be able to work for the defense team at all. But after reading this law review, one of the primary conclusions that I draw is that not only should lawyers not be working as jurors not be working as consultants. Oh my God, 2,500 of you now. Not only should jurors not be working as consultants for defense teams, but there is a very good reason why this situation of a juror trying to join Reed's legal team as a lawyer is going to cause just absolute bombshells and chaos. It's going to be a redo of that 1999 Florida case, the 2000-something California case, and I have to say, I think Alan Jackson did this on purpose, and I think he put this all together. He either had it in his pocket, or he figured out that they could do this. He probably initially was like, what if we hire her as a consultant? Then someone was like, what if we just bring her on the legal team? She's a lawyer. Oh my God. Because a consultant doesn't create an appealable issue. You realize that, right? Like that would never open the door for an appeal. But if you try to add a former juror to your legal team, yes, that could open the door to appeal. All right, so two more things. One more thing I want to do, which is I want to do a review of today. There are obviously a lot of you watching, but at the same time, we have reviewed a lot of material. But let's just start from the beginning of the day, and let's go through the updates that have happened, and then we will prepare, and I will try to get you ready to understand what's going to play out over the next few days, and then that should be a good close. So the day started with me updating the buffer zone. So not updating, but drawing an updated buffer zone map. You can see the new buffer zone in red, the old buffer zone in blue down there on your screen right in front of you. And the new buffer zone is a little bit wider in specific areas. I believe, let's see, is that west? I think that's west. On the western side of the courthouse, it's expanded to Bullard Street and Bullard Court, and then where that is boxed over by Ames Street, and then also, and then the other side on Bullard Court on Court Street. So the buffer zone has expanded to basically prevent people from standing on the church property at all, which they weren't going to be able to do this time. And by the way, let's talk a little bit about, is it that Karen Reed and her supporters chose not to go back to the church? Or is the real story that they're not permitted to go back to that church, buffer zone or otherwise? And what is the reason for that? It's not just Aiden Kearney was persona non grata because of his views that are quite intolerant as to who people love and how they express themselves and all of that. It was something else, wasn't it? Wasn't it, Karen and your friends? Isn't that why you're not allowed back at the church? I don't think Turtle Boy was being very forthcoming last night when he was talking about that. And I think there certainly may have been, I've had discussions with some of the Free Karen Reed folks. I've had discussions just around the courthouse, outside the courthouse, obviously, with some of those folks. And I think, just even from the questions I asked them, I think that there were some behaviors, showing of signs maybe on church property, that might have been not so acceptable. Not the content or anything, but just the very act of displaying any such signs on church property. And maybe that ties into it. But to say that it's Karen not wanting to go back to the church and her team, no. I don't think Karen and her team could go there if they wanted to. Maybe to go to church. Seems like a very welcoming church. I actually I didn't talk to anyone, but I went in the church one time because it was open for, I think they were showing like a tour group around or something, and they just were like, they had the door open and they were saying, if you want to see the church, come in. So it was not even on a hearing day. I think I was there to get a motion or something. So I go in and the tour group's kind of being led around, and I just was kind of looking and on my own. And it is, at least the part of the church that I went in, it is a very old, very beautiful building. And it has this kind of sloped aisleways amongst the pews. So when you go into the building, it's very ornate, but it's simple, and it has a lot of it's very humble. It's not a Catholic church. I think it's a Unitarian church, but it was the first Presbyterian church or something in Dedham. I'm not exactly sure. But anyway, you walk into this church, and it has this sloping sort of 1600s, very old wooden aisles between the pews. And it is so old that when you walk, you can feel yourself going back in time, because you're walking on floorboards that are literally like as old as the United States of America, if not older. I forget, there might have been a rebuild at one point of some parts of the building, but the original well of the church itself is original. It's still there. And so just as an aside, that is some of those buildings in that church complex are very historic, very beautiful. But yeah, I do think that whether the buffer zone was in place or not, Karen and her team were not going back to that church. No doubt in my mind. And it wasn't just about Aiden Kearney. In fact, I think that Aiden Kearney, as he said himself on his stream last year, was not welcome on that church, at that church, even during last year's trial. I think it has to do more with Karen's supporters and just the nature of the dynamics between what the church expected and then what happened. That's kind of how I interpreted my conversations with the Free Karen Read people. But yes, that is a story in and of itself. So that buffer zone picture, although it's just a picture, in and of itself is a good microcosm of this case because it has a bunch of layers and nuance and intricacies to it. All right, so then we already went over the juror joining Reed's team. Then this was the review of the no case law. This was Karen losing her motion to try to exclude one of the Commonwealth's witnesses who's going to testify about John O'Keefe's injuries to the back of his head being caused, in the expert's opinion, by John falling to the ground, clearly after being struck allegedly by Karen's car at 12:31 a.m. on 1/29/2022, and then John falling backwards and hitting his head on the ground. So that expert will be allowed to testify in full. Then journalists for next week's first trial were announced. I have so many classes and projects right now that I don't even know if well, first of all, you can't watch jury selection, but I couldn't even sit there for every day if I had been selected as one of the 10. But I had a lot going on. But those journalists were announced. John DePetro's on the list, Aiden Kearney, Boston 25. Who are some of the other ones here? Let me actually click onto this list 1 second. All right. Where is this? Where is it now? You can tell I've been up for a long time when struggled to even click the post. Boston 25, Boston.com, WHDH, WBZ will be in there, Mass Live, Dateline NBC, and WCVB. All right, so good for all of them. They'll be doing their thing. They won't be on TV or anything. They will be sitting there with no cameras, just watching jurors, unable to hear anything being said as the jurors get chosen, if we even go forward with jury selection. And then so I retweeted someone who said, how is it possible every unprecedented thing in legal history can happen in one case? At this point, we're either living in a simulation or this is some psyop. Yes, I feel like I'm living in a simulation. Every day I'm just like, oh, something absolutely ridiculous is going to happen today. I hope I eat enough calories for my brain to process it all. All right. And then this was the Karen Reed's motion for access so she could have an earpiece while listening to sidebars, so she didn't have to actually stand there. I'm not sure if I guess she's allowed to be there. It's an interesting question. I'm not sure if the court's going to allow it. And then I asked if someone could find me a single case in the history of the United States where a juror from a criminal defendant's original trial went on to join the legal team for the defense as a lawyer. I believe this is truly one of the few cases of first impressions left. And let's see what people said. And someone said, you seem to know everything. I'm sure you can find something. I said, it's true towels are absorbent, but I can't find a case, and I'm not sure one exists. And someone said, nope, they cannot find one case site. Hold on, let me give that person a like. There we go. Someone said something fishy going on here. And then someone else made a comment that I don't think is true. She's helped. I don't think Karen's doing that. I think Karen corrupted the Department of Justice somehow with Alan Jackson and David Yanetti's help. And that was the real corruption in the Reed case and the John O'Keefe case. And then I did an updated list of the motions. We've gone through all of them. We are not going to go through them right now. I'll give you a quick overview. And then there was a new Commonwealth motion for discovery, which has all of the records from the ID documentary, as well as interviews with Boston 25 from Karen Reed and Nathan Reed, maybe Bill Reed. It actually has, let me quickly expand this. It has Ted Daniel interview, Bill Reed, Janet Reed, Ted Daniel, emails to Hank Brennan, emails to voicemail to Hank Brennan, voicemail to ADA Lally, and then a report by an employment lawyer, which I think has to do with Michael Proctor, transcript of the defendant's investigation discovery, episodes 1 through 4, episodes 1 through 5, and then uploaded PowerPoint by one of the defense experts. One of the state experts. And then Karen filed a reply in her federal appeal at the First Circuit. And then let's just check the updated list of motions. I'm going to bring it up on your screen. If you're wondering how many motions are outstanding, we have, let's see, there's 34 motions with rulings, and then 35 through 55. There's 20 or so, because one of them is on a motion. There's 20 or so motions without rulings. Now, if you're wondering what big things have come down in the past few days, you can check out this full list. 1 through 33 has the rulings that have been ordered. For example, things like Aiden Kearney's cell phone, and then the denial of the motion for David Yannetti and Karen Reed's contacts, where there's reportedly a text from Karen to David Yannetti saying Karen hit John O'Keefe, but not that hard, with her car that morning. It's also possible Aiden Kearney's lawyer, Tim Bradle, was talking about that in front of Kearney and third parties who weren't Kearney, and in turn may have revealed that Yannetti was himself talking about that text message. But that motion was denied. The buffer zone motion was allowed. The defense motion was denied, obviously, to exclude the expert. But then there's a bunch of outstanding motions. Some of them are relevant. Some of them just kind of were left on the docket undecided. But the bigger ones that need to be decided have to do with, let's see, the sequestration order, which I think is coming for witnesses. That starts, I think, at the presentation of evidence. I'm not sure if it's at opening statements or the first actual witness. By the way, the motion to prohibit the medical examiner's cause of death statement, that happens in every criminal trial in Massachusetts, and it will be allowed here. And obviously, the medical examiner has a cause of death as trauma in the medical examiner's testimony, so not on the report, the initial report, but the medical examiner's testimony is John O'Keefe's death was caused by trauma to the head, coupled with hypothermia, which was indicated by blackening of John's pancreas. And then the motion about prohibiting references to IA investigations or things like that, no action yet. The motion to prevent the defense from raising a third-party culprit defense without court permission again is still waiting a ruling, and that's very important because the last time the defense mentioned the third-party culprit and tried to use it in their opening without permission. So I could see Judge Cannoni taking some pretty stern action. We might get an actual written ruling on this. Keep an eye on that very closely. Then there's the ARCA lack of bias motion. I don't think Judge Cannoni is going to rule in favor of that for Reed because ARCA was quite obviously biased, and they withheld material contacts and communications from the court. Another motion to try to exclude a state witness. I think Reed's going to lose that too, along with another motion to limit the testimony or exclude the testimony of another state witness. Reed's probably going to lose. And then another one, a Commonwealth motion to exclude one of Reed's witnesses. I don't think that's been ruled on, but Reed did file an opposition. So I need to actually update that because the motion in limine to exclude the expert testimony of Garrett Wing also has a response from Reed, so I'll update that in the morning. No ruling yet, though. And then there was the Commonwealth. Oh, no, actually, this is what it was. It was the motion in the Commonwealth's motion to exclude defense expert witness Michael Easter, and then the defense filed their opposition today. And then the defense and the state tried to delay the trial, and Judge Cannoni said no, but we can revisit this after the jury is impaneled. And then Kearney's intervening to try to quash the subpoena for him to testify. Remember, the subpoena for his phone records or whatnot to the special prosecutor was already in. That hearing is separate. That has to do with the actual content of Kearney's phones. That's going to be the hearing in the next few days. That was the breaking news that started the stream all those hours ago, whatever it is, 3 hours now. And then at the same time, there was the ruling that we saw that brings us full circle, which is Attorney Cosgrove, Robert C. Cosgrove, filed a status report on the Rule 17 motion for Aiden Kearney's phones that the material Judge Stitsky ordered Cosgrove to turn over from Kearney's phone to Brennan in the context of the Karen Reed trial for the purposes of Brennan calling Kearney as a hostile witness to get a consciousness of guilt instruction against Reed by way of Commonwealth v. Mahoney's standard of a joint venture by Kearney and Reed to intimidate witnesses in the lead up to and during Reed's first trial. And then what we got was there was a ruling on that, as I mentioned earlier, and that ruling is what brought us into our stream today. It wasn't really a ruling per se, but it is what's going to bring us like a commodious vicus of recirculation back to wherefrom we once began, and it was this very specific ruling from Judge Stitsky, which is Judge Kearney writes, respondent filed order others ex parte status report of Rule 17. Respondent filed and forwarded to Judge Stitsky. Then we get Judge Stitsky, I think, saying receipt acknowledged and status report to be shared with parties only. So now Brennan has the status report on the material from Kearney's phone, which also apparently had a USB drive. Otherwise impounded provisionally until a hearing before the court. Thumb drive accompanying this report shall be impounded until further action by the court. Parties to appear soon as practicable. J. Stitsky, dated today. Now I see what this is about. The material from Kearney's phone is provisionally impounded and the status report is provisionally impounded until further action by the court. So it looks like the status report we might get to see after the hearing with Kearney and Reed. Oh my God, this has got to be explosive. There's got to be something absolutely massive on there if he impounded it. What is on there? This has got to be it. This has got to be everything. This here, now that I'm actually putting this all together, this has got to be everything. Because why would he impound it provisionally? Why would Judge Stitsky impound it provisionally? And why is it getting kicked back over to Judge Stitsky? Even the status report. Oh my dear God! And these phones are already searched. This is whatever this is going to be absolutely explosive. And there's a thumb drive too. So it's got to be the contents of the phone and then a report on their contents. And both of them are provisionally impounded, and there's got to now be a hearing about them. Oh my word. Folks, if you've been following the Karen Reed trial, this is it. This is it. What a day. What a day. This is one of those moments. You can't predict this kind of thing is going to happen. You can't, and look at, I want to zoom in on that atomic bomb. That is wonderful. You can't predict that kind of thing is going to happen. It just happens. And this is one of those moments. And I think that, and I'm just scrolling through some of the Twitter comments now, of people asking questions. So someone has any clue what this means for us less intelligent followers? I mean, I'm trying to tell you what this means. I don't know exactly what's on that phone, but there's going to be a hearing in the next few days involving Karen Reed, Aiden Kearney, and Hank Brennan, and it's going to have to do with the contents of Aiden Kearney's phone, and it's going to be bared before the world, and all these parties are getting hauled into court. Some of these attorneys are from out of state. Trial starts next week. This is extraordinary. And then we also got the situation with the juror being added to Reed's team. All of this together at the same time, folks, leading to a crescendo of epic proportions that, although it is sad and has disgraced the memory of John O'Keefe and allowed that memory to fall by the wayside, has also established a new standard for legal developments occurring within the context of a criminal case. To the point where, however this case ends up being decided and playing out, there is no doubt that history will make note of it and its various footnotes. It will be etched into the sands of American juridical time, whether it likes it or not. And I'm not sure if that's good for America or healthy for the world, but that is where we are at. Okay, so let me see what's going on here. Someone said excellent analysis. I am out because of Maui Swift telling me to stop replying to someone tagging me. Oh, well, okay, hold on. Let's do this. If B-Boop is tagging people who don't want to be tagged, let's stop that from happening. I don't want anyone to feel unwelcome because of what's going on in chat. And in general, if people want to have debates and tag each other and engage, then allow them to go back and forth. But if someone is intentionally trolling, I mean, just don't do that. I mean, I don't want people to feel unwelcome here. And I'll try to reach out to Amber Am, because even though it's just one person, I think everybody who engages here, good faith, bad faith, or whatnot, should feel comfortable. And as long as you're not engaging in discriminatory or derogatory remarks, I'm generally okay with it. But I also don't like trolling. So if like B Boop is engaging in trolling and then Amber Ann is responding, just that can just go. I think Amber Am should be able to engage however they want. Yes, exactly. I hope we'll be able to reach out to Amber Am. I enjoyed their commentary. I don't know how we'll get that. I'm not saying Maui Swift was necessarily, or anyone was in the wrong. It's just I want people to feel comfortable in the chat. I'm just getting caught up. Why can TB be in the courtroom? Because the sequester order doesn't start until the first witness is called. He tried to quash the subpoena. It probably will not. Everyone who steps foot in that courtroom, this murder by Maestro, should be put on warning. We we need to email. I think that was someone talking about Aiden making facial expressions. Is it impounded to keep TB from trying to get ahead of whatever it is? I mean, it could be impounded because it's extremely explosive, because it contains material that needs to be reviewed. I'm not really sure. I can't. It's because there was no motion to impound. It was sua sponte impound pending a hearing of the court, so it must be a very big deal. TB did kind of walk out of court yesterday in a little bit of a unusual way. I can actually show it to you. I have a clip of it. We can watch this. I guess that's a good end, because I think Turtle Boy was showing his nervousness a little bit when he was leaving court yesterday, and I have the video of it, so I'll show you him walking out. Let's see. At the last hearing in front of Judge Skitsy, Judge Brennan had a video ready that he offered for the judge to watch. Yep. Why did he say it was ex parte? Did Cosgrove and Judge meet? No, I think it was just that the letter was delivered ex parte. It was a status report from Cosgrove to the Reed docket, which went to Judge Cannoni. So Judge Cannoni forwarded to Judge Stitsky. Yeah, I'm just wondering what exactly, I think that whatever is on there is going to be a big deal. But I'm wondering what exactly is on there. All right, let me pull up this video of Aiden Kearney leaving court yesterday, and then after all this time. I think I'm the only one that actually has this video, and I haven't actually posted it, so you can only actually watch it by me playing it. I played it on stream, I think, at one point, but you can only really watch it by me playing it. All right, here we go. I got it. Let me bring this over to the active tab. 1 second. There we go. It's not going to be perfect yet. Hold on. I got to move things around. Yeah, that's not even close. All right, hold on 1 second. I'll make it look decent. The clip's actually pretty good, how it came out. He doesn't really, it was actually quite abnormal, so I guess this was a harbinger. I wonder if Aiden knew this was coming or what was going on. The vibe was different. Yep, I think it's official. I think it's fair to say Towel has stayed up past his bedtime, but that's all right. I'm committed to showing you what this was like, because I think it's very telling. Aiden Kearney after the Karen Reed trial hearing, I think it was yesterday. There we go. It's not perfect, but it's enough for our purposes.
Can I come? I was in school all morning. Listen, I got bunk beds in my house. Oh, do you? How much? How much? Hi, Meredith. Did he say I smell like weed? I definitely smell like weed. I was going to say, who doesn't smell like weed? Do I take showers? I take a lot of showers. Done. We're done. Yeah, back next week. There he is. And she is. But hold on. No, we're gonna. If we're mutual. You want me to be nice? Everybody be nice to Christina.
No, broads are us right here.
Does it not go both ways?
Let's go.
The other girl.
All right. So yes, that was Aiden Kearney's departure from the courthouse yesterday at the end of the Karen Reed trial hearing, and I think, in some sense, you could see, and we'll bring it back to a still shot. If this is a harbinger of where things are going, I wouldn't exactly say he was, his normal self. He definitely felt a little bit, yes, he's smirking and such, but there's an air of nervousness. The crowd wasn't even that large, by the way, when Karen walked out of her hearing. Aiden didn't stay. At a certain point, I think I pan over and look at the crowd, and it's maybe 10 to 15. Outside of the journalists, I'd say it's like 15 to 20 people, 10 to 15 people. There's some cops, obviously, some troopers, and then a lot of news cameramen and reporters, and then 10 to 15 supporters and a towel. But obviously, we need to keep a very close eye on what this is going to mean. Getting this status report from related to Aiden Kearney's phones could happen after this hearing, whether this hearing's Thursday, Friday, or next Monday, and then proceeding from that status report to the actual documents, the material that was on the USB drive, potentially being made public, who knows, is going to be also as quite important. But yes, my name is GrantSmithEllis. If you've been watching for 3 hours, we did another full review today. We covered the explosive update, as I just concluded, about the hearing that's now going to happen in the Reed and Kearney matter related to Kearney's phones and Kearney being called as a witness in Reed's case sometime over the next few days. Then we talked about the juror joining Reed's team as a lawyer, and then we did a deep analysis, and then we went over all the other updates from today. And I am so grateful to all those of you who have stayed for yet another 3-hour stream. I think we have done 18 hours together over the past few days. Really enjoying getting the chance to engage in this kind of stream with you all. I appreciate those of you who have sent support and all of the donations and all of the comments. I'm going to try to reach out to Amber Am to just make sure everybody is feeling okay and they feel comfortable here, and then hopefully we won't have, even if there's hostile goings back and forth, people can either block each other or engage, but just as long as people feel welcome. And then at the same time, Aiden, there were some questions in chat, so let me just wrap this up. Let's see. Aiden's phones were taken long before trial. That's correct. They were taken last year and then searched in November of 2024. And I have a feeling, and I have reason to believe, that Aiden thinks there's very damaging information on those phones. The only legit reason to bring the lawyer on would be if she has info she can't give over as a civilian. Since that doesn't seem to be the case, it has to be the other end of the scale. I agree. I think it may be procedural, have to do with contacts with Karen's attorney. Thank you, Grant. Thank you, Ashley. Amber Am, sorry you feel that way. I said something to them as well. And Maui Swift, I appreciate you jumping in there. And obviously, as I said, I don't think you did anything wrong there. I didn't actually see the exchange going on between Amber Am and whoever that other person was. But I appreciate you, Maui Swift, and I appreciate you making that comment to Amber Am, and I just want everyone to feel welcome. And Maui Swift, your efforts are appreciated, and you spend so much time on these streams. And then I agree, you do wonderful work, and I didn't actually see the context of the exchange. I only saw Amber Am saying she had to go, and I that's all that I was weighing in on. But all of you who are watching, I'm very grateful. It is coming up on 8:30 or 9 o'clock here. So this is about Tal's bedtime. And we will be back again tomorrow. I'm sure there's going to be a flurry of updates. Who knows when this hearing is going to be scheduled. But for now, I'm going to continue trying to, I don't know, keep myself going and fed and continue attending my classes and doing all the other things that towels do. And I appreciate, as I said, not only Maui Swift, but Murder by Maestro, Trevor, all of you who stayed till the end. It means a lot to me. Ashley, Second Beach Girl, Kelly from Boston, Kimmy K, Laxi Daisical, and otherwise. I would keep reading, but there's a lot of you, and it seems like you all enjoy this. I'll try to do these YouTube streams more often, and yes, it looks like that is enough from me for tonight. God bless, folks. Enjoy the rest of your, what is it now, Wednesday evening going into Thursday if you're in Europe, like Murder by Maestro. All right, friends, my name's GrantSmithEllis. Thanks for being with me. I will see you again probably tomorrow at the pace things are going, and please be well until then.